technology law policy that has been coming across for several years in India.
Right. So, before we start, we have, written a report on the grant of software patents and the practice. To introduce the report, I would like to call our research fellow, Mr. Nilesh Shah, who's going to give us a brief overview of the report. Once the presentation is done, there are various scanner codes across the room, which you can scan and access the report, from our website. Nile, over to you.
Thank you. So our report is on software patents in India. It's titled Software Patents in India, Law and Practice. And as the title suggests, it covers a brief history of software patents in India, what the legislative developments have been so far. And it also covers an empirical study about the grant of software patents by the Patent Office and what the implications of this grant are. I believe we have a presentation that should be shared on your screen shortly, but let me just get started. So in India, the legislature had the foresight to exclude business methods, algorithms, and computer programs from patentable subject matter when the Patents Act was amended in 2005. This ensured that software companies in India were shielded from litigation that other technology companies faced, especially in the Western world. However, we've seen over the years that there has been a strong push, especially by larger technology players in the market, to allow software patents to be granted in India. Our report goes over this push and tries to see what software patents have been granted so far and what the implications are. We have seen that the legislative development of patents in India started in 1970 when the Patent Act was introduced, and Section 2 defined what inventions were. With the narrow definition of inventions that was present in the earliest version of the Patents Act in India, software could not have been considered patentable subject matter. However, once India became a signatory to the Trade-Related Intellectual Property Rights Agreement, TRIPS, the Patent Act was also subsequently amended to make it more compliant with TRIPS, and Section 21J was amended to redefine what invention meant. I'll just briefly read out that invention meant a new product or process involving an inventive step and capable of industrial application. It's from this definition of invention that we finally see the grant of software patents in India. However, the Act of 2005 also introduced a caveat under Section 3K, which said that a mathematical or business method or a computer program per se or algorithm would not be an invention. Since then, we've seen that there was an ordinance that was issued in 2004, which amended Section 3K of the Patents Act to read as a computer program per se, other than its technical application to industry or a combination with hardware. This caveating created a scenario where software patents were much more likely to be granted. However, we did see that the legislature, when it was passing the Patents Amendment Act of 2005, did not deign to include this provision in the final act. Can you please go to the second slide? Thank you. Yes, so this is the empirical study that we carried out. And as you can see, it covers patents that have been granted by the Patent Office from 2014 up till 2022. And the Patent Office, as you know, publishes its official journal every Friday on its website. And this was an arduous process where we went through all the applications, and because there's no easy way to find out whether a patent has been granted or not, the methodology adopted was to go through the entire database that we had to analyze them for patents that were granted in violation of Section 3K. As you can see from this table, there has been a significant number of software patents that have been granted to foreign entities in comparison to Indian entities. The numbers through the years reflect that they have either been in the single digits or in the low 20s. What is the implication of this? The implication is that, firstly, despite a statutory prohibition against granting software patents, we have seen a significant number of software patents being granted. Secondly, there has been a steady increase in the number of software patents that have been granted, especially up till 2019. where the number peaked at 1,192. And lastly, that it is mostly foreign firms that are availing themselves of these software patents and not Indian firms. We can see that the grant of these software patents is likely to cause a problem for the Indian software industry in the future and even at the present moment. Can you please go to the next slide? Now, how exactly does the Patent Office grant these software patents? We do have a set of guidelines that are released periodically, and you will see that these guidelines have oscillated from one position to another. We don't really have a singular position that has been adopted by the Patent Office over the years. In 2008, we saw that the Patent Office, based its interpretation upon the European Patent Office practice and not upon Indian legislation. It deigned to allow software patents instead of what the Patents Act said. In 2011, however, it categorically stated that patent applications relating to mathematical methods, business methods, and algorithms, even if describing technological developments, are considered to be not patentable. However, we see a switch again in 2015, where there was an examination procedure that was laid out to be followed when patent applications relating to computer-related inventions were to be examined. They would consider similar steps as that for other inventions, which is novelty, inventive step, industrial applicability, and sufficiency of disclosure. The 2016 guidelines slowed down the number of software patents that were granted in India because apart from the three-part test that is followed, there was also required to be the presence of novel hardware. However, as is the case with India, we saw an immediate flip in 2017 where things worsened greatly, and there was a 54% increase in the number of patents that were granted. Not only was the three-part test removed, the further technical effect test was removed as well, and software inventions were treated on par with other inventions. As it stands, we have the revised Manual of Patent Office Practice and Procedure that was released in 2019, which confirmed and reiterated the 2017 guidelines. Rather than excluding software patents, they included them and made a small caveat excluding certain software patents and granted blanket patentability to others. To obviously learn more about this from people much more learned than I am, we're now going to have Arjun introduce our moderator and panelists for the session. Thank you.
Thank you for that very broad and very excellent overview that you have provided, Nilay. So I would just like to announce that the report, the Software Patents Report, Law and Practice, is now live, and everyone present here, you have the option of accessing it. You have the scanners on both ends of this room. Everyone who is logged in online, we have it available on the website, and we will be sharing the link as well. Going forward into the depths of the first panel that we have, and an interesting title to it as well, and which should become clearer as we delve into the nitty-gritties of this topic. India's Trojan horse in the land of FOSS. SFLC has been a huge believer right from the very beginning in free and open source software. However, the latest practices, as pointed out by Nilay, have been a certain taint on the processes, and it is a very pertinent issue that we will be discussing today regarding the grant and the processes through which software patents have been granted by the Indian Patent Office. Our first panel will be moderated by Ms. Mishi Chaudhary. She's the founder of Software Freedom Law Center India and is a technology lawyer working with an eminent cybersecurity firm in Washington, D.C. She has legally represented some of the world's leading open source software developers, such as Debian, the Apache Software Foundation, and OpenSSL. Mishi, I hand it over to you.
Thank you, Arjun. Can you hear me? Oh, yeah, you can. Prashant just said to me that 10 years have gone by and it's the same panelists. And but I did tell him we are much older, actually, all of us. This was a lot of jargon, a lot of different words you heard. several guidelines and manuals and 3K, etc. For us nerdy lawyers, this is music, but that's not how policy is made. And that's not how we think about several issues impacting innovation. And ultimately, these devices that are in your hand through which you are negotiating your lives these days. Why this is important will become clearer slowly. I promise that the software patents panel will be nerdy. So for all of you who want to dig deeper into these questions, we will deliver on that. But overall, why this matters to us, why from the very inception of the Software Freedom Law Center, we've been talking about these issues is that the idea of copyrights, patents, etc., was to promote innovation. But then once Americans find everything, they also want to keep it for themselves and ensure that the rest of the world follows whatever they would like in terms of laws. In India, we talked a lot about knowledge sharing. Venki and I go back and forth into talking about the same thing, that in our culture, it was always about you shared knowledge, it increased, and then the remix culture happened. That's why building on what was already done in the world became the way of free and open source software. We definitely hacked the copyright structure because that's the law. And after TRIPS, most of the world wanted to work under the Berne Convention in a certain way. On the patent side, India, which had a pharmaceuticals industry and had seen a major experience about what process or product patents can do for you, had a little different approach here. During the pandemic, all of us also saw the exposure of this system. Every time you would talk about pharmaceutical patents, you would heard there is so much money which is required for research and development, and there is only one blockbuster drug which comes out of that process. So obviously we need patenting for 20 years so that we can reap those benefits. But you also saw this time, like all the time, that it was public money which is invested in a lot of research and development. However, the knowledge transfer does not happen at the same rate. India did produce vaccines, but that doesn't mean that a lot of the other vaccinations on which the rights, the intellectual property rights, were also transferred in the same way as we would have expected. This part is important because we've had a big services-based industry for a very long time. And then we changed with TRIPS to a product-based industry also. Free and open source software community, without which the 70% of how the internet runs would not work. Most of the things which you are now in your pockets, all the apps would not run. And we wouldn't be in the place where we are today in terms of the internet economy, has always understood that trying to control knowledge, development, and education is not going to work. And when we started doing this work long ago, we also understood why this can actually derail the entire innovative process we are looking at. That's why the title of Trojan horse. It's also Sisyphean. You solve one problem, you think the problem is solved. 2 years later, it comes up again in another form. The second half of the day, you will see, we'll talk about IT rules. Prashant and I like to do these really small circle. You see that many people have joined online, not so many people have turned up in person, because what the hell is software patents and what is this 3K, etc. But these boring sounding things have such a large impact on who gets sued, who gets to produce, who is allowed to actually have a lower entry barrier so that they can innovate. That's the discussion we have. This is a very exciting panel for me because they're all my friends. But I also know that they're experts. They're deep experts who've spent a lot of time on this matter and on this issue. We may not be joined by one of our panelists because she's perhaps stuck in court right now. That happens with lawyers. It is a Tuesday after all. But we will try to have this discussion so that for several of us, it will become clearer why the matter is important, why people are investing, I will tell you about the various panelists who are joining. I will not read their resumes. You can all look them up. They're very accomplished, and you can find out how they have spent their time. That is why they are experts in the field. But it is my great pleasure to do this discussion. I hope all of you will take away, if nothing else, at least one thing as to why innovation is only possible when we all decide to follow the rules of share and share alike, instead of control and keeping it to ourselves. So I'm going to start sitting there and let other people talk, but join the discussion. I know cell phones are very attractive, but they're also very distracting. So if you could silent them, it would be great. You're obviously peeking into your own cell phones on your WhatsApp messages, but I'll urge you to invite other people on your social media channels to talk about this very esoteric but extremely important topic. If you do believe in digital India as well as innovation, come join us in this discussion. And I'm going to sit. All right. So today, to my left is my very dear friend, my partner in crime, Prashant Sugathan. He's the legal director of the Software Freedom Law Center, in addition to other hats he wears. And he has been part of this fight. In fact, that's how Prashant and I met in 2008, talking about software patents. Then Swati Sukumar, who is supposed to join us, is an off-counsel for Oban and Associates, which is an IP firm here. We're joined by Dr. V. Sridhar. He's a professor at the Center for IT and Public Policy at IIIT Bangalore. Professor Sridhar is joining us online. I don't think we need to see our faces on the screen. So if you can get the people who have joined online, their faces, that would be great. Thank you, Professor Dr. Sridhar, for joining us. Excited.
Sridhar, Michelle.
The next here is Venkatesh Hariharan. He's the Public Policy Director for FOSS United. Venki and I met when he was at Red Hat. Red Hat, which is now part of the largest patent owners in the world, IBM. But Venki's commitment to free and open source software goes back a long way. We again became friends because open source was important to us, what India was producing and how India ensures that there is an umbrella over the Indian economy so that we are not spending our time paying lawyers' fees, but actually innovating. So Venki has done a lot of work in different roles. And then last but not the least is Dr. Nagarjuna G. Nagarjuna is the chairperson of Free Software Foundation India. He's and one of its founding members. Both Venki and Nagarjuna are also the governing board members of the Software Freedom Law Center. And Nagarjuna is a true believer, enthusiast, teacher in the power of free and open source software. There's nothing like a sight of Nagarjuna sitting on the ground and teaching children how to actually make software, which I have been lucky enough to witness. But very excited to have all of you here. And we'll start the way, because I'm chairing the panel, I can have a little control over timing. I'm going to ask each of these people to have a 2 to 3 minutes opening statement so that you can all at least get an understanding of where they are and what their stance is and why. Thereafter, I'll ask a few questions. We'll try to make it more conversational. The last 20 minutes are allocated for audience interaction. But if you think that you have a much more important question than I have, which always happens because I hang out with smarter people and you all are smarter than I am. So bring in your questions and we'll start. But I'm going to ask Dr. Sridhar to start with his opening statement. And I apologize if I will hold you all to time. But let's hear Dr. Sridhar and then we'll slowly move through the other panelists.
Thank you, Mishi. So I hope you are able to hear me out.
Yes.
Okay, so I'll just discuss this along three dimensions. First is technology. Software has become omnipresent. In fact, as we speak, ChatGPT is writing software programs. So it has become very difficult for us to find out whose invention the software is. And I'm not a lawyer, therefore you can find out whether 3K is applicable to software that is produced by software. So that is one of the ambiguity in software patents. The second one is the economic aspects. So most of the times patents are given to give monopoly rights so that the patent holder can set the price and then select the audience for adoption. And in general, the prices are high and the adoption is small, but the profit is enough for the monopoly rights holder to offset the R&D expenditure, the upfront cost. But in countries like India, where we have economies of scale, the number who will adopt is going to be huge. And therefore, it is in our interest to keep the price low. And therefore, we are actually moving away from monopoly to standards, which will set the ball rolling for low prices, high economies of scale, and still the inventor will be able to reap enough profits to offset the cost. So that is the economic dimension, which is in favor of commons and standards and against the monopoly rights offered by patents. The third one is jurisdiction. So, for example, most of our IT services companies have the markets in the US, and therefore they apply for patents in the USPTO. But the multinationals now seem to have, the big tech companies seem to have a large audience in India, and therefore they come here and then fight for software patents. In which case, who is the winner? You know, for example, our IT service companies or even startups, for example, if they invent a software, they will not have wherewithal to fight against the big techs. And therefore, it is in our interest to stop this whole process of giving software patents, because it will lead to a lot of litigation, and the Indian companies, especially the startups in India, will not have wherewithal to fight against the big techs. If we want software patents, we can always go to US and then file it in USPTO. That's where the addressable market is. So that's my 2 cents, Mishi, and then we can take the questions later. Over to you.
Perfect. I didn't even have to actually tell you about the time. Dr. Nagarjuna, why don't we move to you for your opening remarks, please?
Yeah, can you hear me?
Yes.
Yes. Yeah. Well, so there are a lot of legal experts on the panel and possibly also in the audience. So I would like to start with a couple of important foundational reasons, based on the nature of knowledge construction, knowledge creation, because innovation has to be rooted in that practice. So we need to do a lot of rethinking, particularly because of the digitization of several of the human activities that are requiring us to rethink, particularly after because the kind of intellectual property instruments that the world has created happened during and post-industrial revolution, right? And therefore, those instruments, if we continue to use and abuse in the current context without rethinking, there is going to be a serious problem, because the nature of software knowledge is I would not say substantially, but then sufficiently defined, different from the other forms of cultural practices that we have, particularly because verbatim copying of the creations is possible with high fidelity, and therefore that important aspect has to be looked into. And then therefore the traditional instruments of authenticating and protecting cultural expressions and providing incentives for them need to be rethought about. And one major and foundational aspect that we need to worry about is that, just as natural languages have a generative grammar, the grammar of all languages has some peculiar characteristic features, which has been, one can say, is what one might say is refined formalized and made available to us in the form of mathematics and logic. And then today, on the basis of the foundations of mathematics and logic, we now have a new form of expressing through software programs so that the machine can understand, which essentially requires us to move from metaphors and analogies that are used in languages to defined terms and defined procedures. And that is the basis of software, how software is made. And therefore, it is entirely based on a generative grammar. And generative grammar is available and accessible to, I would say, to the human body itself. I mean, it has been used in the cultural practices forever, except that we have now formalized and made them work with machines. Now, with this slight change, we cannot transform what is eminently copyrightable expression into, a patentable innovation. And that will create a lot of problems. I think people have already mentioned how difficult it is to use software patents, and then, and it will actually, granting them would be advantageous for the bigger monopolies rather than, small-time developers as well as practitioners. Now, one other problem that emerges because of the formal character of the software itself by nature is the determining the source, the original source, because the basic operations that are used are encoding, decoding, storing, transferring data from device to device, and modulating the transformations, encryption, etc., etc. And all these operations are available to us for quite some time, and they are based on mathematical operations. And these operations are combined in a particular format with different kinds of algorithms, and that is a creative potential that the programmers have. And that generative aspect of that is one of the reasons why it is very difficult to determine originality and original source. And that difficulty is the reason why, it will end up into, as Mishi said, into enormous, endless litigations. And we will not be able to resolve them in a very cut and dry method, because we are not dealing with material or substantial nature of the knowledge production at all.
Dr. Nagaraja, I'm going to ask, move on to the next opening statement, and we will come back to the crucial point you have made about determination of originality. I'm going to move to Venki. Venkatesh Hariharan, as I said, is the Public Policy Director and has been doing this work over some time. Venki, over to you for your opening remarks, please.
Thanks, Mishi, and thanks to SFLC for doing a very painstaking job of the empirical study on software patents. I know it's not an easy job to do. I've been involved with this issue since 2005, when we met the then Minister of Commerce. And, when we met him and spoke to him, he made one statement which set alarm bells ringing in our head. He said that all the MNCs have approved the draft patent amendment that we have created. So then we started scrambling to get our hands on a draft, and then we worked with policymakers across India to get the law which would have said technical effects of software can be patentable subject matter. And so the current language that we have, which says that mathematical or business method or computer programs per se or algorithms cannot be patented, was a result of some of the work that we did in 2005 to 2008. Unfortunately, since then, this has been, a battle which reminds me of those zombie movies where you attack the particular problem and it just keeps coming back in different forms. So once, we had Section 3K in its current form approved by Parliament, we thought we had won the battle. And, then to our horror, we saw that in the draft patent manual, which came out, I think, in 2008, the exact same language which was thrown out by Parliament was brought in. And since then, we have been fighting this fight. So I'll, share a quick bit of the geopolitics of this. And I think one of the things with software patents is that it is seen as a form of neo-colonialism. Now that the industrialized economies, the developed economies have lost, the grounds in terms of manufacturing, etc. This becomes a method for them to control the value chains and global supply chains, the global value chains. So if you look at the proportion of the profit pools that these organizations control through software patents and through, patenting, you will find that, the disproportionate amount of patents, the profit pool goes to these industrialized developed economies. Let me give one example, and one of the reasons why the Chinese are so aggressive when it comes to software patents and generally patenting as a issue. In the early days of DVD players, the DVD player used to cost about $20, and the Chinese used to pay something like $10 in royalties to a whole bunch of global companies. When the price of the device itself came down to something like $20, they were still paying $10 in royalties to a bunch of these MNC firms. And just think of it, it's these companies that are, taking the risk of inventory, doing all the entire hard work of supply chain, logistics, etc. And their share in the profit pool was extremely low. So they have taken a very proactive stance. But I think in India, we have not really understood the geopolitical dimensions of software patents and why it is important to push back against it. And this is reflected in the wishy-washy stance that the patent office has taken when it comes to putting our foot down on the issue of software patents. So when you say per se computer programs cannot be patented, per se means that intrinsically computer programs cannot be patented. So then why are we seeing patents on things like machine-to-machine interactions, etc., which means that, even this Zoom call that we are doing is violating a particular software patent. So I think it's time that, we in the FOSS community also acted and, coordinated more aggressively to push back against software patents. And I'll reserve my other comments for, these are my opening remarks. I'll reserve my comments for later. Other comments for later.
Well, thank you, Venki, for bringing the Chinese in. There's no discussion in the world without the Chinese there. And here we move on to Prashant for his opening remarks, please.
Thanks, Mishi. Yep. In fact, the discussions which were started in 2005, 2008, unfortunately, we are still discussing the same topic. Nothing has changed as far as the law is concerned. It's the same. In fact, when Nilay made the presentations, the act was amended in the year 2005, and that's the current form that we have it. So software, computer programs per se, algorithms, business methods, mathematical methods, these cannot be patented. That is the law as far as India is concerned. Now, if you try to draw a parallel between the pharmaceuticals, what happened in the pharmaceutical sector? India has become a major supplier in the pharmaceutical sector for the entire world, thanks to the laws that we had at that point of time prior to TRIPS, thanks to the process patent laws that we had. We could have a lot of pharmaceutical companies in India, which could take advantage of this and become really big and become major players as far as the world is concerned. Similarly, when it comes to software, it is thanks essentially to Section 3K and the kind of umbrella which Mishi was referring to, that the Indian tech sector, the Indian software sector could really ensure that they could really outperform other companies, other, let's say, companies across the world. And with the belief that there won't be anybody coming there to attack them in the legal space on patents. But what we are seeing now is, although the law has not changed, what is happening is there are new practices which the patent office is coming up with in the form of various patent manuals, the CRI guidelines. So there is this classic book on software patents called The Patent Failure. The title reads, How Judges, Bureaucrats, and Lawyers Put Innovators at Risk, written by James Besson and Michael Muir. In fact, that title itself tells us what the problem is. It's essentially the judges, bureaucrats, and lawyers who are putting innovators at risk. So that's exactly what's happening in India. In fact, our parliamentarians had the foresight, and this was one of the bills. I mean, unfortunately, not much debate happens in Parliament now. But as far as the patent bill was concerned, that point of time was extensively debated. And an MP made a valid point that if you are going to bring in software patents in India, it's going to affect the Indian companies. The multinational companies will will prosper, but that will be at the cost of Indian companies. Now, the statistics which Nilay took you through, that shows exactly that. If you look at the patents which are granted in violation of Section 3K, it's largely to foreign companies. So, thankfully, unfortunately, I would say, it's as in the bureaucrats which are hampering the progress of Indian tech. So definitely we all need to discuss this, think of what are the solutions. The problem, we thought there was a pushback from the free software community, from the Indian companies. When the initial guidelines came out, the manual came out, then to 2016, it was modified. There was a clear 3-part test which was introduced in the manual, which ensured that patents in this area, which were in violation of Section 3K, were restricted. But unfortunately, it's gone back to what is, it is not that bad as how it was in 2016, in 2015, but still in the 2017 guidelines, at least looking at the numbers, we can see that there are a lot of software patents being granted. So let's see what can be done. It's for the community to stick together and see. We don't need to change the law. The law is already there. But yes, the practice definitely needs to be changed.
Great. Thank you, Prashant. You can tell we are ready to take on our own community. He's blamed the judges. He's blamed the lawyers. He doesn't like money, obviously. And he said that we are the ones who are stopping innovation. That does happen, actually, because when we forget why laws exist and we are only interested in the enforcement of it, or to be able to talk about pros or cons, because lawyers always win, whether you're on this side or the other, and you forget why something exists in society, that is bound to happen. And that's why it's also incumbent upon the same lawyers who can understand these 3-part tests or this 3K or whatever per se or definitions we are talking about, is to break them down and change the policy so that it can serve the larger purpose of the society. Because laws don't exist only for themselves. I am always fascinated by these numbers. I think that it does sound a little protectionist. It does sound like India should only cover itself, nationalists, and cut itself out from all of it. So to all of you esteemed panelists who perhaps have now talked about why the law is perfect, it is the details, that devil in those details, whether it is rules or manuals or CRI guidelines, etc., where the problems lie, and they can be used to change a bunch of things. So my first question, and I'm happy for all of you to jump in one by one, is that most proponents always claim that patents are about innovation. Time and again, we will see the number of patents filed as a matter of innovation. You will hear IBM has so many patents. When I was growing up, I was told my niece in America is 9 years old. She has 5 patents. We are so innovative in America. And we still do that. Whether it is the large system integrators in India, the names of which you all are very familiar with, everybody says these are the number of patents we have filed. I want to ask you all, is that a correct way to measure progress in this area? And if it is not, what is your alternative suggestion? Because you've said mostly India has decided no software patents, and this is good, this is fine, but then how or what is the metric to measure innovation? And why are you telling us to cut us off from the rest of the world, what US does or what other people do? So I'm going to ask Dr. Sridhar to bring you back in the conversation because it's been some time. What do you think about that as a metric?
Okay, so Mishi, what is the objective of an innovation? It is to create social welfare, right? So if you measure social welfare as one of the metrics by which the innovation can be determined, then we are talking about how ubiquitous the technology is being adopted, right? So for example, we have seen the classic cases of the software, the standard essential patents being used in standards in all the mobile phones, which has made possible the access to mobile phones to billions of people. And therefore, instead of looking at the rights, if we look at social welfare, what is the amount of social welfare that is generated by the technology in question, then we may be able to sort of look at it more practically and see whether it is at all required in order to protect the rights or to improve the social welfare. That's my view.
Venki, what do you think? You've been in the software industry for all this while, and some of your ex-employers filed patents for defensive purposes, some filed for innovative purposes. What do you think? Is this the right metric?
So I have seen a whole bunch of patents. In fact, I think in the last year or so, I went through about 20 different software patents. And if you look at these patents, you'll be really hard put to say that, hey, this is innovative. So there is a large tech company which has filed for a patent on machine-to-machine communications, which is, I think, completely bogus as a patent. And then if you look at globally, there are, examples of really funny patents. There is, somebody has got a patent for exercising a cat with a laser pointer. Somebody's got a patent on exercising on, swinging on a swing sideways. And his argument was that typically you swing in a front and back kind of a motion. I have added an inventive step, which is that now you can swing sideways. So I think if you look at the vast majority of patents, particularly in the field of software, you'll find that a lot of them are not really very substantial. There is very little inventiveness in them. In fact, a friend of mine who used to work at Google, he has about 9 different patents in his name. And he said that the lawyers one day came to him and said, what can we file? So let's file for patents. So he shared some of the stuff that he's working on. And then when it came back from the lawyers, he couldn't recognize that it's his own, ideas that are expressed in this legalese, and it's just become so complicated. So I'll just also build on what Nagarjuna said, which is that today we are trying to use industrial era tools to govern a digital society. And an example of that is the fact that today the nature of innovation has completely changed. In the industrial era, you had to create a working model, submit that in the patent office, and then on the basis of that, you would be given a patent. Today, the innovation model has completely changed to collaborative innovation. If you look at, say, Linux, Apache, many of the major open source projects, the 2 things that have enabled collaborative innovation is one, you can form communities on the internet. You can, create, groups which have shared interest. And then you have the legal framework of the open source community, which is that, you have the freedom to modify, the freedom to share. Because of that, most of the emerging technologies, whether it's blockchain, whether it's big data, AI, ML, are all now happening on open source, free and open source software. Collaborative innovation is the new paradigm. But the existing structures don't really factor that in. And if you look at, say, reports like the recent 161st Committee, Parliamentary Committee or IPR, it has absolutely no mention of the model of collaborative innovation. It has no mention of, the free and open source software community and the rapid innovation that it is generating. And why is this important? Because today, every startup that you can think of if you look at their tech architecture, it's completely built on open source software. And then if you start, what we are doing is creating public goods worth billions and billions and billions of dollars. And then, if you layer software patents on top of it, that is completely diametrically opposite to public goods. It's basically private goods. It's a private monopoly. And then the question comes, from a policy perspective, when so much of innovation is happening in the open, when people are disclosing their ideas and inventions in the open, why do you need to privatize that and give monopolies to individuals? I think from a policy perspective, software patents are a very bad idea, because when innovation is happening in the open, giving private monopolies to innovation, a 20-year monopoly on a particular idea, one-click shopping, machine-to-machine communications is, I think, in policy, a very bad idea. Let me stop there. I can come back to that later.
Nagarjuna, let me come to you. Venki said most of the stack these days is built on open source. I want to understand do FOSS licenses, the free and open source software licenses, what do they say about patent rights? Are we saying that the world should not have patents, or are we just saying that India should not have it because it's in the law? And then how do we actually participate in this ecosystem while protecting ourselves as well?
Yeah, I wanted to address both these issues. One of them, of course, is the metric issue that you asked the other panelists. I think which Venki also mentioned, that the collaborative platforms where knowledge production and publication happens, such as, for example, the Git repositories. In fact, if you start looking at them, you would know like which applications actually use whose creations. I think if really somebody wants to incentivize the creators, we have a fascinating knowledge base from where you can understand which core libraries or shared libraries are actually being used to construct new software and new applications. So that is one of the interesting kind of metric, and that is the kind of metric that would apply to the current model of software production, and therefore we need to downgrade the existing models of creating incentives to the creators, because we know exactly whose ideas who is using and things like that. So we have a complete, in fact, let me put it this way, the complete, unlike in the past, the complete footprint of creative creation is archived, particularly in the free and open source software model. And now, answering the question that you asked specifically to me is that, dealing with the current situation within the free and open source software, one best strategy that appears to me is publish by expressing not merely the software, but also the design of the idea as clearly and unambiguously as possible within the Git repositories, so that the prior published ideas cannot be patented by other people. What I'm saying is that free and open source software people do share software almost regularly, every hour, every minute, and things like that. But what they not do is they do not formally present their design as clearly and unambiguously as possible. And making that available will prevent people to patent the formal structures which are already being used and reused almost all the time. So that's why that's one of the things, which essentially means that publish as soon as possible your ideas on a Git repository, which is public, so that these ideas are not patentable by other people.
So let me clarify here what Nagarjuna is telling us. Most of the software innovation these days is happening in collaborative models. So you have version control histories. GitHub becomes the place. Microsoft pays that huge amount for something it actually used to call a cancer of the world. And then all innovation is now being done globally in collaborative models. That is protected by copyright. Most of the open source licenses are governing copyright, some of them do have clauses on patents, and they talk about their implementation, whether it is the Apache software license, which governs the Android software in your phones, or the GNU GPL various versions, and they talk about patent rights in a different way. So Nagarjuna's point is copyright is sufficient. We all decided it's sufficient. It tells us what the provenance is. It tells us how, who does what. And anyway, innovation is happening. And the history of the free software movement tells us that patenting software has actually not contributed to the important software innovations of the last generation. Then why are we wasting everybody's time? I'm going to ask Prashant, who is the lawyer here. And Prashant, you've said already that the law is pretty clear. Everything is sufficient. The law is clear. What is the motivation of the Patent Office to actually ensure that 90% of irregularly granted patents should be given to foreign companies, and they're enabled to make it difficult for Indian companies to operate? Why are they doing it, and what's going on? And what have you been doing for the past 10 years for that?
Well, I like the last part. Sure. So let's look at what's happening at the Patent Office. The question. See, one major problem that we are seeing is Patent Office is often influenced by what is happening in the rest of the world, thanks largely to the training that they often get. This is mostly from the European Patent Office or from the US. And the law as such in the EU is quite different from what we have here. Although they also have some restrictions on computer programs, patentability of computer programs. If you look at the law there, what we tried to incorporate by the ordinance in 2004. So for example, where there's a technical effect, it could be patentable. So that is the kind of test that is often followed in the EU, where if there's a technical effect, the software could be patented. Same with, if you look at Indian law, there's a complete exclusion for business methods and mathematical methods and algorithms. But that's not the same in Europe. Europe, the same test applies there. If there's a technical effect, then it could be patented. But then when the Patent Office gets trained by persons who are coming from such a jurisdiction, coming from the practice that they are following, then definitely causes an issue. And this is what happens when the European practice spills over to practice here in our Patent Office. I believe that could be a major issue. What you find, I mean, the skewed patents being granted in a violation of our own law. Then, I mean, is there a reason why foreign firms are getting it? I don't think there's a direct correlation. It could be mostly because of the number of applications that they're filing. And a lot of foreign firms are filing applications in this area, in the area of software. But if you compare the numbers, these numbers have also been going up. That is also showing a correlation between how the Patent Office practice has been kind of oscillating. It went down when the three-part test was there. So three-part test, I will take you through how it worked. The three-part test was very clear. The first, what you need to do is figure out where is the invention coming in, what is called the contribution. So if it is in, let's say, the excluded area, that if it's in mathematical method, algorithms, business methods, this is completely excluded as well as Indian law is concerned, then deny the patent. Then if it is in the area of software, computer programs, what the Patent Office needs to do is figure out where exactly the contribution lies. If it is only in software, then deny it. But if it is in software along with the novel hardware, then it can proceed to other forms of patentability. That is novelty and other factors. So that is how it was. But then this test was taken off 2017 CRI guidelines. So when the new guidelines came. So that is where the problems came in. So yes, the law is very clear. Patent Office practices, it keeps on changing. So that is where I think, we need to do something about it. There was one more question.
One question was, what have you done for last 10 years?
Okay. So initially, what happened earlier? So in fact, we all came together. Manual came right in 2005. Then there were conferences. Thankfully, the manual changed. Then subsequently, in 2015, and the manual introduced, CR guidelines were introduced, which were like very problematic. Then we had this consultation process, talked to the ministry, we talked to the DIPB, the patent office, and the consultation and the interesting is in the Mumbai patent office. It was like Goliath battle. 2% on this side. It was me and the lawyer friend from the civil society, and 50% on the other side, mostly from software companies, the bigger software MNCs, and the bigger law firms from India. So, but thanks to those discussions at that point of time and the stand which the government took, the patent office took at that point of time, the three-part test was introduced in the patent manual. There was a change, and we thought things had changed for the better, but then it was like 2 steps forward and 1 step backward kind of a situation when the next CRI guidelines came.
Yeah.
So, Prashant is giving you a little bit of a slice into how this fight is such a big problem, because startup economy is thriving, but they're much smaller. They obviously do not have the wherewithal or the resources to spend on a team of lawyers who will be examining patents. And the way patents work, if you have seen, is that you get punished also to study those patents because there's willful infringement damages. Now, but the larger players, which are mostly international players, do have the wherewithal to ensure that whatever they have already patented in the US or Europe through the Patent Cooperation Treaty, they can also get priority in India. And the protection just extends. I want to understand from our panelists, why do they matter for our thriving internet-based digital economy? And how are they impacting the larger incumbents and startups differently? And if the case is that the new tech does not want to be encumbered or held back because of these patents and what is going on here, and we risk that, why is it that this little thing is happening irregularly, even though the law does not allow, and we are letting it all go and nobody is taking any note of it, other than the fact that obviously very small organizations' efforts continue to happen. And if you can tell us what the state of affairs is and how we should be approaching this question in a simpler way, that would be great. I'm going to again follow the same order. So Dr. Sridhar, why don't we start with you to talk about a little bit about the economics of all of this, and in terms of policy decisions, how should it be viewed by us?
Mishi, I think the narrative has to change, right? So for example, I mean, we have been looking at monopoly abuse in the competition law. And the competition law amendment has taken into account certain aspects of monopoly abuse. We have seen intermediary immunity being taken away to some extent in the Digital India Act as well as the IT Act Amendment Rule 2021. And we have seen the emergence of open systems such as ONDC, Open Network Digital Commerce, UPI, semi-open, and also we have seen account aggregator and other public infrastructure which is coming up. So the narrative has to change. What we offer in India is the scale of operation. And therefore, if you go with open standards or digital goods or digital public infrastructure, then there will be an opportunity for all of us, right? Consumers, all the stakeholders will get the benefit. And that's the narrative that we want to give, right? So that the lobbying by the large companies can be prevented to some extent. And the startups will have the leeway to leverage on the economies of scale that we have in India to basically thrive, survive. See, it is not in the blood of the startups. I work with a lot of startups. They don't want to go to the court, right? I mean, they want to get their technical solutions scale up and leverage the huge population that we have, the internet economy that we have. And that's their strength. Let us leverage that strength to a change in the narrative. That's my view.
Great. Narrative which helps frame the issues and also to work out the details later on. Dr. Sridhar, I'm just going to press you a little bit here also. Is this an actual problem, or it's for currently the ecosystem? Have we seen anything that tells us this might become dangerous, or is it already an issue?
The change of narrative, Mishi?
No, just the software patents problem. And
Yes. So I mean, we have seen the telecom sector, we have seen it in the digital platforms sector. We have seen the lobbying, right? We have seen the lobbying of the big tech companies. And therefore, if, for example, we let it go, then it is quite possible that it will become difficult for our startups to thrive in the Indian ecosystem because of the infringement and other litigation processes that they might have to go through. So I think that it is time that we change the narrative towards more open, large-scale public infrastructure to be developed in the country, and hence the need for amending the software patent laws, or at least enforcement of the state software patent.
Venki, I'm going to come to you. Is this a problem? And how does it impact the actual newly thriving digital economy? Also, if you could add, I think Nagarjuna already said, if we were to be publishing our code using the way software is made, that at least creates prior art, so makes it difficult for other people to patent. Does this defensive publication work? And are there other ways people can think about protecting themselves?
So I'll give a practical example, and this whole question of, is it in favor of big companies, small companies? So if a ant steps on an elephant, the elephant is not going to die. But if it happens the other way, the elephant steps on the ant is going to die. So let's take a thought experiment. If I'm a young student in a college and I have created some software, and suddenly it becomes very popular, people start downloading it, then I start building a business model around it. And once I've started commercializing it and newspaper articles appear, suddenly somebody comes out and says, hey, you're violating my patent, therefore pay me X amount of money. So just that single letter from that patent holder sets off a chain of events that is an extremely costly process. So if I have to get a legal opinion, I don't know, the minimum cost might be somewhere around 2 lakh rupees. If I have to go to court, maybe another 10 lakh rupees. And if I'm a small software company, I may not have the ability to withstand this kind of legal uncertainty. Let's assume that I'm in the middle of fundraising and I'm looking to raise the next round of capital. If there is legal litigation hanging over my company's head, the funders will say that you sort out your litigation and then I will look at the next round of funding. But until you do that, I'm not going to fund you. So I think it just creates this kind of a extremely convoluted dynamics which are in favor of large companies who have the capital, who have the stamina, who have the wherewithal to fight a legal case over a long period of time. And it's extremely damaging to smaller companies. Now, coming to your question, and what Nagarjuna mentioned about defensive patents, this is a system that actually works well. It's a defensive game that we need to play, and I'm not extremely in favor of it, but in situations where you have no other recourse, I think it's a good methodology. So Unified Patents has something called PATROLL, PATROLL. And if you go to the Unified Patents website, what they do is they give out bounties of $2,000 to $3,000 to people who help find prior art. And in many cases, the prior art that has been found through this process has been used to invalidate a number of software patents. I'm also happy to say that many of the winners of this bounty, many of them are Indians. So this it's a good way to do that. But I would say that, given the current realities, the most important thing is to look at how we can get better enforcement of Section 3K, which says that computer programs per se cannot be patented.
Great. Nagarjuna, can you talk a little bit about other forms of patent pooling initiatives? We know that Linux systems does make usage of something very interesting in order to ensure that anyone who is member of that patent pool or does an open source implementation of Linux systems or anything coming out of that has another way to defend themselves. Can you talk a little bit about that part and open source community in general about what they have been doing in other parts of the world to protect themselves?
Well, I think if you really want to change the narrative, since that's what Sridhar was also mentioning in another context, there is one important aspect that I think we need to look at. I'm not directly answering your question, but the issue that we have here is that it's a kind of asymmetric kind of world at this moment. Take, for example, if I am a free software developer, I publish my code, and then I claim copyright on a published code, right? And when it comes to proprietary software and all these big companies, what they do is they're claiming copyright as well, but then their code is not published. Now, I really don't know how this kind of an asymmetrical world is actually going to work. And as a result, the game will always be in the favor of those people who actually have a copyright and they have never published those things. And because it's only the binary code that is accessible to people. And as you know, binary code is not really the place. And then you are also forbidden to reverse engineer the binary code as well legally. And therefore, the protection is always in favor of one. And in such a kind of an asymmetric world that we have, where the systems are protecting that kind of monopolies and monopoly practices. So how are we going to actually play the game? It's really going to be a tough one at the end. It's not just merely the legal cases and court cases, but and the expense and the access of the legal support that is required. But it's actually a complete asymmetrical kind of system that we need to rethink about. I don't have an answer to this, but I think that this is a problem that all of us have to think about and try to see how we can resolve this issue. Of course, I certainly don't have an answer to this question, but I'm sure you may be a better person to actually say exactly how the various organizations which got together and trying to take care of some of these patentable issues within the free software world.
Well, I have to say, nobody pays SFLC all that big money that we keep hearing about lawyers are charging for this work. But I'll ask again for free legal advice from Prashant. Prashant, is this a problem? Why are we actually trying to do all of these issues? And why are we trying to address them right now? And talk a little bit about the alternatives of patent pools, non-aggression communities that have come together around the world. And if you can tell us that we've already seen this problem in the rest of the world, and that's why we are trying to solve it before facts change on ground, or there's some other reason because we like certain things.
Of course, we have seen it in the rest of the world. And it's not that it's not happening here. It's already happening here in India. There are litigations. Now, let's start from the problem. I'll go back to the book Patent Failure. And what the major issue here is, See, it's quite different from the pharmaceuticals. There, it's very clear you get a patent on a molecule. Everybody knows what the patent is on. The boundaries are very clear. Now, in patent filer, they explain this. They draw a parallel between patent and property rights. Now, you have a piece of land. It's very clear to everyone, to the government, to the person in your locality who has this property. It is evident from the revenue records that you have this specific property. But when it comes to this right, which is again called intellectual property, right? Patent is again a part of that. It's a subset of that. This again is considered a property, but what is this property is not very clear. So the problem here is you can exclude everybody else from enjoying this. If they are, as Vengi was explaining, you are, let's say, developing a new software. Without your knowledge, you could be infringing on somebody else's patent. There is no way that a software developer can know about it because the boundaries of that patent is not clear at all. To give an example, there's something called the point of sale devices, which you find in all these supermarkets.
Yeah.
So what happened is when there was an e-commerce stores being developed, the checkout process is almost similar. The same thing that you do in a physical store that you do in a e-commerce store also. Then you can't imagine that the patent application or patent granted for a point of sale application could be extended to even an e-commerce store. So that's what happens. So there is no way a person who is developing this application can have any idea that he could be infringing on a patent granted for something entirely different. Now, let's look at the scenario here. We should refer to India and whether are we just imagining things. Definitely, we are not imagining.
Why can't you just challenge a patent in a post-grant opposition?
Okay, I'll come to that later. Now, so in fact, when it comes to various algorithms, even mainly the telecom sector, we are seeing a lot of litigations, and we really don't see those judgments because these are often settled out of court. Nobody wants a closure of business. Nobody wants an injunction being granted. So what they often do is the moment a case is filed, they try to settle this. And that is how patent litigations work across in most countries. And that is in fact happening in India also. We hear about this, but nobody knows about the amounts. We don't know what is the agreement. Most are not disclosed at all. There are agreements which prevent disclosure of such agreements. So end of the day, we don't know what's happening. But definitely, this is spilling over to India also. And this could affect the software sector. The Free Software Committee is not thinking of various problems that could happen. It is in fact happening. So then the question about, in fact, we were mentioning earlier about how the legislature, the parliament had the foresight to come up with the provisions in our law, preventing software patents. They also had the foresight to come up with something called a pre-grant opposition and a post-grant opposition. So you have a opposition before the patent is granted, and then one after the patent is granted. Now, on our part, we have tried both, and I would say failed miserably at both. Not
bad lawyering.
It has been, in fact, when we had the first conference, I think in 2010, that time, I think one day prior to that, we filed our first pre-grant opposition. That's still not decided. We just got a notice a few weeks back. Then there is a post-grant opposition that we have filed. That's also again more than 10 years now. So you need to understand that the life of a patent is 20 years. Now, if it takes more than 10 years to challenge that, they have already enjoyed the patent. So that's what happens with a post-grant or a pre-grant patent opposition.
So I obviously deliberately asked that question to tell you that there are consulting firms who also have patents. For example, the one patent which Prashant has not talked about, but when we challenged it, it was supposed to be an expert sitting in a remote location is imparting knowledge to another person in another location. Please tell me how any of these people can participate in this panel. They are experts, they have knowledge, they are sharing it with all of you. And we're infringing on several other things. Many of the tech which works today will read on several of these patents. Patents is also a poker game where you exchange chips. That's why you see, unless there is a major concern between large firms, if it's a Google Oracle case, or it's a Samsung case, then we see some litigation that happens where they can always cross-license. That's not possible for smaller firms. Venki, if you can talk a little bit about Open Invention Network, that would also perhaps help the audience get a little understanding about patent pooling.
Yeah, I think so. The Open Invention Network is a very unusual entity because while it is set up as a for-profit, it functions almost like a non-profit. So I think so many years ago, Microsoft basically said that Linux violates our patents, and they had put a set of patents on the market. And the fear was that if it fell in the hands of patent trolls, then Linux users could be litigated against. So Open Invention Network was formed around that time. And what we did was we got an organization to buy out those patents, and then in turn, we bought over those patents. And over the last several years, we invested about $100 million in buying out a portfolio of about 1,000 patents. And we give a free, royalty-free license to anybody who wants to join Open Invention Network. But the condition is that if you become a member of Open Invention Network, you agree not to assert your patents against other Open Invention Network members who around basically the core of Linux, the core of the Linux kernel around critical infrastructure pieces in Linux and open source like blockchain, etc., etc. So there is a set of some 3,000 software packages which are called the Linux system definition, and all OIN members agree not to attack each other. And now the interesting thing is that some of the largest tech companies, Google, etc., have all become members of the SpaceX, Toyota, etc. We have a large number of banks coming in, almost about 3,500, 3,800 members. And the most interesting thing is that in 2020, I think Microsoft also joined Open Invention Network, because finally, I think they realized that their competition is not Linux. And now that they've moved to a cloud-based strategy, this entire old battlefields don't really make sense anymore. So Open Invention Network is a free service. In India, we have Reliance Jio, Zomato, Zoho, Zerodha, Infosys, Wipro, and many other companies who are members. And globally, we have like some of the top tier technology companies as members.
Thank you. Amazon recently joined Open Invention Network. Open Invention Network actually is, as Venki said, a patent pool. Community comes together and says if there are non-practicing entities, which are colloquially known as trolls, we need to protect Linux system, because that's the basic of how the internet works, or any other digital economy today works, any other part of the digital economy works. You will see 3,700 people, entities and companies around from 150 countries came together and said, we need something else, because the world's patent system is not doing its job. It delays, it causes a lot of other issues. And this started in the US. I think in India, as all the panelists have already said, it's rarely that I hear such kudos for the parliamentarians, but as you've seen that everybody has told you how foresighted this parliament was, and they knew everything about these nerdy, detailed topics. They made the right decision. We do have the right law. We're just not doing the right implementations. And we are trying to noodle through rules or guidelines here. If some of you have questions about what you've heard today, or comments or inputs, this is your chance. If anyone has anything online, please look at that. Venki has also put in a link in the Zoom chat about patent failure. The book Prashant talked about? I hope this is the calm before the storm. You are all going to change the entire landscape of software patents. That's why everybody is too quiet. If there are no questions, I think I will continue to ask yes, please go ahead. If you can also state your name and your organization, that'll be great.
Myself, I'm from and I'm working as a program manager at the MHF of the Government of India. I need to, sir, ask to you that what the sir has said, that the binary output thing is there, and startups and small companies need to publish the code, but the big MNCs did not have the liability to publish their code. They have the liability to read the published code available. And why this disparity is there, and what is the solution for that problem? Because this is a major challenge for a small startup companies as well as the existing companies in the pavilion. So what is the solution of this problem, and how we can eradicate this?
Nagarjuna, I think the question is directed to you, but it's perhaps about the difference in proprietary software and FOSS. So if you might want to take that question.
Well, actually, we don't know how to resolve that issue, right? Because it's the way how the system is created across the world. So I think this is something that is to be debated. Again, putting the confidence on systems like Parliament, because these are the issues that the parliaments across the world are meant to resolve. I mean, we have to, because this is a great asymmetry. Because I really don't understand how copyright works on unpublished document. Like, can I write a poem and I don't publish but claim copyright?
I don't think so.
So then why is it that the unpublished proprietary software is granted intellectual protection? I don't know. I mean, this is a very naive question because I'm not a legal expert, right? I mean, but this is the perplexing question that I always had, and I mean, the gentleman who asked this question, I mean, I don't have answers, but we have to find answers by asking this question to everyone.
So I'm going to take the prerogative to jump in here, at least to say some lawyerly thing. The requirement of originality is pretty low in copyright regimes. The moment you create and the moment you save something, you already do get copyright in it. Unlike a patent or a trademark, you're not trying to register something. You can, if you want to go and actually start a litigation, but that's how it comes. I think one of the questions which does happen is that it is a choice. Proprietary software companies distribute it under licenses where they would like to charge for the things in a different manner than how open source collaboration happens. Using the same legal regime, just doing it differently. I might want to invite you to my home. Prashant does not want to invite you to his home, and he would rather charge you a ticket for that. It's that. The only thing which has happened is now internet has worked on where people have decided to share, and we're trying to negotiate that terrain here. I think there's a question here. Yes, please. But thank you for raising that point.
Actually, am I audible?
Yes.
So it's an addition regarding the pre-grant opposition. So I mainly work in the pharmaceutical patents.
Maybe have your name.
My name is Shreyas. I'm a practicing lawyer in Delhi. So I mostly work in pharmaceutical patents. So, and we are a pro bono litigation firm. So in March 23, there's one of the biggest event happened in India regarding the pre-grant opposition, right? So it's regarding a MDR TB medicine called Bedaquiline. It was produced by the Johnson & Johnson. It's a subsidiary of the Johnson & Johnson. They had the patent of this Bedaquiline, okay. So one association, one organization in Maharashtra filed a pre-grant opposition, and two individuals from Delhi also filed a pre-grant opposition. and it was very well researched and detailed pre-grant opposition. And subsequently, the patent office rejected the evergreening patent. Actually, they had patents. So evergreening means, so once your patent is going to end, so what these big pharma companies and any other company would do, they will make some changes in their product or process, and they will file a new patent application. It's a evergreening. So under the Indian Patent Act, 3 subclause D is one of the barrier for this evergreening, and it's a kind of a protection for us. And under 3D, the patent evergreening has been rejected. So when it comes to the software, for example, Ferid Alani is one of the bad judgment. Okay, so myself, I'm saying it's a bad judgment. So Ferid Alani, what the Ferid Alani did.
So is the question?
Yeah, it's a kind of addition. So pre-grant opposition is very important. It's because when the patent office in Ferid Alani case, the patent office gave only 2-page rejection. Okay, then they filed a appeal in IPAB. Then IPAB reversed. So the problem was that the pre-grant opposition, the organization which is working for the against this kind of evergreening and patentability, we have to work more and file a detailed pre-grant opposition, because it was just a search optimization. Ferid Alani was just search optimization was in 90s. It was there, but they granted the patent for that. So we have to work more on pre-grant opposition.
There's a question also which is being raised in online. It's to Venki. What is the benefit foreign firms are gaining by filing so many software patents in India?
Yeah, so the answer is quite simple. There are about 11,000 patents on e-commerce. There are close to some 5,000 patents on online shopping. So and most of this is of course filed outside India. And if those organizations that hold these patents start filing them in India, suddenly we will find that the payment gateways that have come up in India, the e-commerce websites that have come up in India will all have to start paying royalties, because nobody is going to spend time and money filing for patents and then just sit on it. I mean, you file for either defensive purposes or offensive purposes. So once you have this open the floodgates, I think we will quickly find that Indian companies will have to start paying royalties, and whatever benefits we have gained from free and open source software will be wasted or frittered away by paying royalties, fighting litigation, etc., etc. So a very simple answer to what Professor Rahul De has asked.
Deepak.
Deepak Maheshwari, I'm an advisor, a member on the advisory board of SFLC. So I think 3 things. Number 1, the patent grant process itself is extremely long and very detailed process, and it's not everybody's cup of tea. For example, I mean, I was involved in something, and I think it was filed in early 2013, and I still don't know if and when. And by the way, there's not even any opposition to that grant. Okay, so there's no such thing, but it's been almost more than 10 years, in fact, now, and I don't know. So as Venki did mention that, yes, it's a 20 years life, but let's say, unless this is granted, I can't even assert, or let's say the group of people, we can't even assert that particular patent in that sense. So I think the window of opportunity for monetization also gets shortened by this whole delay on both sides. So there are things on both sides. Second thing is, it's not true that companies do not make some of those announcements public. For example, in 2007, Microsoft did have so 2 things they did. One was a collaboration with cross licensing with the novel that time, where the figure was publicly announced. I don't remember the exact figure, but it was announced.
Yes, it derailed our GPLv3 consultation completely.
And the other one was, that time the company also made something called OSP, Open Specification Promise, for a certain set of patents. Not all the patents, of course, in the portfolio, but that's one thing which did happen. The third thing is that I think there's a dilemma even within the country, and not just in India, in many other developing countries also. On one hand, we are saying that yes, software patents, etc., there are challenges in terms of, they should not be granted, etc., etc. On the other hand, both as a country as well as several startups, they are literally developing their business models using the same patenting mechanism. So, for example, yesterday I was at IIT Hyderabad. So they are saying that they have got 125 patents out of 100 startups in the past 4 years through the startups on the campus. And that's something which is, so they're saying it was the matter of pride. Today, India is talking about patents in 5G, for example, 5G specifically, but also on 6G, a lot of stuff is happening. So on one hand, we are saying that yes, these patent grants, etc., should not be undertaken in this manner. On the other hand, it's also, so whether you call it defensive patenting or anything else, but that's another thing which is going on. So yes, ultimately, as and when somebody has a huge significant portfolio, that's when people start negotiating and of course influencing. And lastly, what is happening is in the case of standard essential patents, I think that is the biggest game about which people should be talking about, because obviously individual patents, etc., will happen, people will have those litigations, but the large scale impact will happen through the SEPs. And I think that's one area where we should be focusing more. Thank you.
So, Deepak, before you came in, we had the first part of the section actually of the discussion mostly about the fact that proponents often claim that patents are about innovation, and they use that as a metric to your example about startups. The idea, and I think the panel did talk about that fact, that whether that's the right metric. But here, the idea about the fact that the law does not allow it, and we're talking about irregularly granted ones, and which is what the software patent study does say. The important point, which I think we all didn't get to discuss, and that's why this goes on, and you'll see a lot of case law is there. Ericsson has been pretty, business is no longer there, but it does have a business in standard essential patents. Because once you have those patents, how then you actually make it into a revenue model out of which is done by large companies is an important point to discuss. I'm gonna, I didn't expect us to run over time. There's a question there. If panelists can stay and answer those
I'm
questions.
I'm working as a consultant. My basic question is that the patent system itself is, a lot more distorted and a lot more, inefficient as such. Because if we see, the same Microsoft, same Apple, same, big tech firms are basically growing simply because they do not use the, patent system efficiently. They simply going for mergers and acquisitions of, through finance or through government lobbying. So, for example, if we find that Paytm basically uses the government model of, fintech, etc., to, reach the last mile connectivity for India. So basically, who gains out of it? Only the Chinese company like Paytm. But as far as the Indian firms, startups, or for that matter, Indian financial institutions suffer because of that. And even in the sustainability model of today, ESG models and all that, where we find health tech, etc., we are finding that, a lot of these only big tech firms are only, flourishing because of that same Schneider, same, so basically these are the only narrow firms who are basically benefiting because of these patenting model, because it's not something that creates innovation. For example, the innovations comes from Israel, etc. Same companies basically go over there and acquire some of the patents from there, or so that, and ultimately that creates a lot of long-term risk as far as the entire innovation structure is concerned. Thanks very much.
Thank you. We're gonna wrap it up. I'm gonna ask all the panelists to have at least a very short concluding statement, and I'll start with Prashant.
So at least from the discussion, what we're seeing is definitely software patents are not going to help the startup sector or the growing tech industry as India is concerned. So what we need to do is stick on to the law, make sure the practice is in tune with the law, with the kind of foresight that our parliamentarians had, both with the law with respect to software patenting and also the procedures regarding pre-grant and post-grant opposition.
Venkatesh? And
Yeah.
also, there were a few questions which were directed to you. I'll later put you in touch with, but right now, if your concluding statement.
So I've answered some of the questions in chat,
Okay.
but my concluding statement is that I think the world has completely changed. We are now living in a world of collaborative innovation. Innovation is happening really rapidly because we do not have these artificial boundaries of software patents, and therefore I would say that this whole system of software patenting is actually anti-innovation because it throws a barrier to collaborative innovation. So I think the world has completely changed, but our mental models on software patents have still not changed. Time to update ourselves.
Nagarjuna?
So I have not a closing comment, but a kind of a suggestion that maybe some of us could work on is to, particularly visit or conduct events inside big R&D institutions where, for example, every month or every 2 months, I keep hearing announcements in my institution that so-and-so expert on patents is going to come and he's going to tell us how to patent, how to, so they're going to be some kind of consultancy offering, etc. that is going to happen. So this kind of events are happening, and therefore it's also important to approach these organizations to offer this kind of debate as well, which to create opinion and generate discussion among both the professors as well as the engineers and other people, as well as the students, particularly because most of these institutes have a large number of students who require to understand many of these things as well. So if we really want to, rethink about this old instruments that were invented for the industrial age, to reshape them to the digital era, I think we need to create that kind of dialogues in these institutions. So maybe SFLC or maybe other organizations can start thinking about organizing such dialogues in all these institutions, which might develop, generate a lot of opinion. Maybe eventually the parliament will hear that there is a need for restructuring.
Dr. Sridhar, you have the last word.
Yes. So emphasize on large-scale adoption of innovation through shared and liberal property rights, change the narrative, and don't let innovations confine itself to niche small markets.
Well, that is very succinct. I will urge you, especially this question which was raised perhaps on Zoom as well, if we have information about patents that are being granted on products being built on top of India's public digital infrastructure. It's very hard to actually figure out, to study every single kind of patent. That's why we urge you to actually look at SFLC's report right now, which does tell you about the number, the empirical study, but the qualitative study is going to be much larger undertaking. And but at least it tells you the numbers and the division between the Indian entities and the foreign entities. Please follow sflc.in. If you're in the room, then you can look at these QR codes, which are not my favorite thing, but still they're useful. It helps save paper. Otherwise, go on the website, look at social media channels to look for these things. I will say two more things here. Prashant talked about this to me. We had a conversation. We want to close the session by paying a tribute to our very dear friend, Professor Shamnath Bashir. Shamnath passed away some time back, but he lives literally in our hearts and minds, mostly because of the important, compassionate work he did to make us all realize why laws matter, and why and how you can use the license you have as a lawyer to bring more justice in the world. This does not give us money. it does give a lot of other people money. But starting from the very beginning, which whether it is Dr. Sridhar started about the idea of social welfare, what is the public benefit we are deriving out of all of these things? Is this a metric in fundraising, or is this something which is going to do better for our entire society? And if India is building all this tech infrastructure, are we slowly going to be always, or not slowly, actually always, the sword of Damocles hanging over our head, that something is going to fall someday and we are going to lose it in patent litigation? I'm always grateful to have an advisory board. That's why Deepak is here to talk about standard essential patents. When you think about USBs, when you think about JPEGs, when you talk about various telecom standards, why now people believe in open standards and open source, which is going to actually do it. That's what Venkatesh and Nagarjuna's point is about. We live in a collaborative innovation world. You can't have the same old. Even Microsoft has changed. And so we need to think about these things. Thinking again of Shamnad, who would talk about these matters mostly in the pharma world, but also just encouraged everybody to add spice to their IP and also think about these issues from a much more critical point of view and to find more confidence in our own culture. India's had a culture of knowledge sharing. We can always hack the other systems which have been in place. That's what open source movement is all about. And think about those matters. Also, we're all dreamers, not just my shirt, but the fact that we can make change happen. You really do have to start from one small thing, and changes do happen. The law right now looks the way it is because many a times, Prashant, or people at SFLC.in have been in those David versus Goliath battles. Thank you for joining us for this discussion. We'll open for those of you in person for lunch. For those of you online, please buy your own lunch. Don't send me the bill. The work of software patents is expensive enough, but truly deeply grateful for all the panelists, Dr. Sridhar, Dr. Nagarjuna, Venki, Prashant, Swati couldn't be here also. Hopefully she's fighting on this side in courts and not on the other side. And all of you for joining. Participate in the discussion. I know it's a little esoteric as a topic, but it is pretty important. Once you get in, it becomes much more interesting. And join SFLC.in's team here. Many of these people are 100 times smarter than we are and younger also. They are going to take the fight forward. Join it, talk about these matters, ask questions. There are truly no dumb questions. If they will entertain me, because I always ask dumb questions, they will entertain anybody. But thank you so much. And hopefully you will stay for the rest of the conference as well. Thank you.
Thank you. Thank you, Mishi.
Thanks, Mishi. Thanks, SFLC. Bye.
Thank you all for joining. And after a break, hopefully we will see you again.
So we have a goodie bags for you. And Mamta, she's our treasurer and operations lead. She'll give us.
See, they never give us our own things. So now we have to organize events to get our goodie bags. So I am very grateful to have it. Well, thank you. You can all see what is in there. They're selling all of this to you, but they're giving us all this stuff for free. So, and my favorite one is this one, which says "Likh kar lenge azadi." So pick up these pencils, buy other stuff, and join us for lunch.
Yeah, lunch is served. Please help yourself. We'll reconvene at 2 o'clock. Thank you.
Just want to quickly check, am I audible? Can someone confirm whether I'm audible?
For instance, a shutdown that takes place, or in another matter, there is a data privacy concern a citizen has. All of the pro bono legal services that are provided will be directed to that individual in that state. And it is towards this end, we are also happy to report that we have 25 very excellent candidates, lawyers who have joined us. And they have experiences from 3 years to 25 years in the legal profession. All of them have been very successful also in their own professions, but the baseline understanding of them joining the network is to protect digital freedoms. I think that becomes a very important highlight of the Digital Defenders Network. And we're quite happy to report that also we're seeing it play out effectively. So there recently were certain shutdowns that had taken place in Jharkhand, and we had our lawyers undertake legal redressal at the earliest. And while it is a long drawn process and it cannot be absolute, however, we're happy to report that it is underway, and we would also undertake any and all support that we can get towards this endeavor.
Thanks, Arjun. I think, we've bored you enough with so many details of our SFLC, but I hope that you can pass on this information to people, who are interested in such things. I'm sure lawyers everywhere, and we also provide trainings. So I hope, our public education initiatives can be taken advantage of. Now, moving on to why we're here. So, Digital India Act, right? It's a couple of consultations on this. It has already happened, but we're still sort of confused on what's happening. So the aim of this panel is to draw into the life cycle of technological regulation in India, with the purpose of identifying hits and misses that have happened, and so that we ensure that coming into a new act that doesn't get copied, and there is a far more rights respecting legislation that is out there, right? I would, not taking too much of your time, I would like to introduce you to your moderator, Chitranshu Tiwari, who's sitting right here. Chitranshu leads product and revenue at News Laundry. He's interested in media and its intersection with big tech, and is among the first media leaders who have shaped the subscription news model in India from ground up. So Chitranshu, over to you.
We can all sit together.
Yeah.
Yeah, then we can start.
Yeah, I think it would be a great idea for the panelists to come in. Professor Subodh Sharma, who's the Associate Dean, he has joined us online. He's right there. Mishi, Ashish, Dr. Maheshwari, Mr. Maheshwari, Dr. Seth.
I'm going to take this opportunity to welcome you all. Some of you were not here in the morning with us. After the pandemic, I think the hybrid model is here to stay. And a lot of people are joining us online to participate in this discussion. I'm seeing some old friends and some new faces, and it's always a pleasure to have more and more people join the discussion. When I started the Software Freedom Law Center 13 years ago, and that also tells you my age a little bit, I didn't expect that there would be so many different topics which would be covered under the umbrella, as well as what the organization addresses. I am always excited to hear more and more viewpoints and the people who participate in these discussions. As a believer in multi-stakeholder model, which means that good policy can only be done or made in a collaborative fashion. We're not here to say, oh, gotcha for the government or the companies, because unless we all work together, we are not going to get the results which we all desire, which is ease of usage of technology, rights respecting, and something which also takes India to the forefront of all kind of conversations. We are all very fortunate enough that geopolitical factors have also realized the creativity as well as the innovative intellectual might of what India offers. And that's why there is much more responsibility on us as the fourth pillar. There is the US model, which is a license-free model. There's a European model, which is much more about regulation. And then there's the authoritarian model. And India does present that kind of a leadership opportunity where rest of the world looks up to us. So very excited that the team has put together this panel, and people who are now joining us are from all walks of life. Dr. Seth, Mr. Maheshwari, and Chitranshu, and our dear friends here, this is what I was just saying, that many of us have been doing this for so long. Sometimes, I think Deepak said, it's the same menu and the same venue. And I think next time we're going to change the menu and the venue, and hopefully it will be much more interactive as well, and not a place which is going to charge us per person for internet and per screen. But very grateful for all of you to be here. And hopefully we can continue to the participation and also get an opportunity to see each other face to face. I myself love the hybrid model considering my travel schedule, but I would really love to see you more and participate. And now I will turn it over to Chitranshu. Thank you.
Great. While Mishi was talking about the menu, I was just thinking this is actually one of the cheapest venue in the city. So great. Thank you everyone for coming in. Post-lunch sessions are always tricky, but I hope all of you had a nice lunch and had just enough carbs to not fall asleep. So I'll just give some context to the panel as to how I see the subject. I think it's very important for us to also understand why we are having this discussion at this juncture of time. So there are two key legislations that are upcoming legislation. One, like Radhika said, is the Digital India Act. Second is the Data Protection Bill. Both the legislation put together are going to impact the way we interact with the internet, right? And also a bunch of digital rights that we associate with the internet, right? From user privacy to data protection, so on and so forth. Once both these acts come into play and once they are passed in the parliament, they're going to drastically change how we see the internet. So as citizens, as people who use internet, it's very important for us to understand the subject. What are the kind of concerns that we have? And I think we have a very interesting, diverse panel today. So we have Ashish, who heads policy at NASSCOM. So he can basically represent what is the kind of tech, what is the kind of viewpoint tech industry have. We have Mishi, who's obviously co-founded SFLC, so she can also put in from a legal perspective and also from a civil society perspective. We have Mr. Maheshwari, who's actually worked with Mighty Ministry, and we obviously have Dr. Seth, who is a lawyer, and then we have so both. So it's a very diverse. So what you will essentially see in the panel is you'll see very diverse viewpoint. The one thing I should certainly tell all of you, while I was researching last night, I actually read that Ashish is actually very fond of fencing. So when it comes to tough questions, I'm not going to put it to Ashish for sure, because fencing seems like a very serious sport. So I just want to start off, and this is, I would like everyone on the panel to weigh in on this. I would want us to start by talking about the act that is upon us. If all of you one by one, starting with Ashish, if you could answer, what are the kind of challenges and opportunities you are seeing with the Digital India Act? Are you cautiously optimistic about it? Because again, we have had, both in terms of legislation, we have had a very piecemeal approach whenever it comes to internet or digital rights. We have a chance where a lot of it will have at least one document or a couple of documents that we can all refer to. So do you see this as an exercise where you're very optimistic about it, or do you also see that this is also a chance that the government can take to introduce a lot of censorship, which a lot of us in media have concerns with, and we'll obviously come back to that. So if all of us can answer this question one by one, Ashish, why don't you start first?
Thanks. I'm very happy to be here. So us public policy folks are eternally optimistic. So I think every time there is a new law coming up, we are like, okay, this is the time we are going to fix it and do it much better. So there is a huge bias there, but that's the position. Having said that, I think if you think about laws dealing with complex technologies, we haven't even started. So IT Act came in 2000. Think of what complex technologies we were dealing with then. I can't think of really anything that was complex when you look back today. What is complex today? Two easy examples of complexities are around AI, Web3. You can talk about encryption technology if you want to talk of encryption as technology. And if you think of any of these things, I don't think we have come to grips with how exactly we're going to deal with it. So there are three thoughts which I have in mind. One is to say that, we are woefully inadequate and short when we think of analysis and studies that deal with the impact of regulation or impact of business models. We don't have enough of it. And if we and wherever TRAI, CCI, or Niti Aayog has done it, it's piecemeal. And sometimes it's also difficult when the regulator is doing it in many ways. So I think that's one. And second one, which I mentioned about the complexity that we haven't even dealt with, and we'll talk about it. And third and the last thing is that there are blind spots for the government and industry when you're thinking of regulation and policy making. So if we can realize that these are blind spots and deal with them when we are dealing with law, consultation process, it's a huge blind spot for government. They will think that it will invariably happen well, and you don't therefore. So the point that we'll discuss about it later in more detail. And the last point is that when we are thinking of asking something to be implemented as a law, we have to reconcile what the law is asking with what is technically possible to do at scale, and do it in a manner that it fits the operating models. And KYC is a good example of how we think about that as something good to do, nice to have, and is it feasible and doable. So I think some of these things is what, when I think of the DIA, it has opportunity to take head on and possibly get it into a space where the objectives can be reconciled. So I'll stop here.
Correct. Mishi, do you share Ashish's optimism, or are you a lot more skeptical?
I think Ashish is right. There is no other way to exist if you're not optimistic. But it's also Sisyphean. We feel that some progress has been made, and then you're like, oh, a few years later, we're again right to the square of -1. Now we have to start all over again of certain things. When we did IT rules in 2011, and I think many people in the audience, Deepak, Vikram, etc., who've been through these rodeos several times, know that conversations are very similar. I'm still optimistic. That's the only way I can exist, or SFLC can exist. What does create this kind of optimism is the potential India has, and also how the rest of the world views India. And what creates pessimism for me is sometimes we forget our own position of leadership as how the world perceives us. It's not a matter of criticism, or it's not a matter of encouragement. It is that leadership is lacking in the world. Whether it is about many of the other developing countries who are leapfrogging into new technologies. I live half of my life in the United States, which has legacy infrastructure, and their policies obviously cater to that society. As I was earlier saying, European society deals a lot more in regulation. There is no European Twitter or a Google or a Facebook, etc. They have understood how to protect their citizens through regulation. And the authoritarian regimes, whether it's the Chinese ones or the Iranian ones, have a very different view of all of these matters. And that does not give any encouragement to anyone who's trying to have democratic values, but also make policy, and leaves India out. And that's why the potential, the kind of progress we've already made, as well as the kind of pro-humanity IT, which we can create, gives me a lot of optimism. And the pessimism is when I feel that civil society is told, come for the pictures after all the big deals have been made. And the power players of government and companies have already decided what is to be done. Thankfully, we have seen quite a lot of difference there, that there is consultation processes. We get to engage and talk and participate constructively. And because without listening to different kind of diverse communities, if we are going to come up with policies, those policies will serve only a very limited purpose. And that's not what a country like India can afford both at the national or the international level.
Mr. Maheshwari, if you could just weigh in on the same thing. But I was also thinking, since you were with the ministry for a really long time, and you must have seen a lot of these processes on your own, like the process of consultation, like how Mishi mentioned right now, the process of inviting diverse viewpoint, the process of inviting different stakeholders to come weigh in before it's actually drafted. So if you could give us some insight, because you are the only one on the panel that has seen that process a lot more closely, and if you could tell us whether you're feeling optimistic or you have a lot of skepticism as well, given that the scope of the act.
Yeah. So, good afternoon, and thanks a lot for having invited me. I just left government about 15 days back. I do remain optimistic in terms of what a new Digital India Bill or Digital India Act, as and when it comes into force, should look like. We have had the IT Act came into existence in 2000, was amended in 2008. A lot of the small amendments have also happened in between, maybe not because of IT Act, but because of other acts. And very recently, a Jan Vishwas bill has also moved in the parliament, bringing in amendments in more than 40 acts with an aim, particularly that the criminal penalties for the corporates are either completely eliminated or are drastically reduced. Because at the end of the day, in corporates also, it is one fine, maybe neck, which you will be able to get, and that's it. Because in crime, in criminality, that is what you are actually looking for. If you have to, really decide. So that doesn't really solve the problem. So problem can be solved if you are looking as to what businesses' needs are, or where the problems are, or where maybe the contraventions are, and to accordingly do a proportionate kind of a maybe reaction rather than going in for criminality. So these are some of the things which have already happened. In fact, very recently, the Schedule 1 was also amended. Now, Schedule 1 in IT Act was actually like a negative list, which has been very drastically reduced. That means the scope of IT Act has been actually enhanced, and I'm sure that goes a long way in once again creating ease of living. So those are some of the things which are going to be there. Having said so, now let's look at as to, and I may take a bit longer, as to what went wrong and what went right with respect to the existing IT Act, either in terms of definition or in terms of implementation and enforcement. So government aim, as which we normally mention in all our parliament questions, is to have an open, safe, secure, and trusted and accountable internet. Now, when we say all these words, we are primarily looking for what exactly citizen requires from any act, and particularly the acts like cyber laws, whether it is maybe IT Act or maybe the personal data protection. And they are looking for their rights to be protected. They are looking for their safety on internet. They are looking that in case something goes wrong, the action must be expeditious, and action must be to ensure that their trust and safety remains. From a corporate perspective, they are looking for that. In fact, the citizen also is, because citizen is also looking for data security, data protection, personal data protection. And when the same thing, I look at it from the corporate perspective, they become the accountability of the organizations, of the government. And so these two things go hand in hand. And to that extent, the IT Act, while there was a provision for adjudication, for example, particularly for any data breach, any unauthorized data access, any data unauthorized data copying, or maybe loss of sensitive personal data or sensitive personal data getting leaked. The fact remains that while this act provided for the proper adjudication, maybe on ground, adjudication has not really worked the way it was intended to. And therefore, any change, any new bill which should come, should definitely look for adjudication in a comprehensive manner, so as to have not only the kind of contraventions which are covered today, but to maybe also cover reasonably good number of cyber harms and illegalities, for which if people are looking for a civil solution, they should be able to get it fast. We have seen in these many years that particularly the corporate world or the digital world has, and the social media particularly, has grown very big to the extent that they sometimes are bigger than the country in terms of their turnover, and they have therefore the huge muscle power as well. Till about 2 years back, Facebook India and Facebook Inc., they were different. And anything you ask, because the people you are knowing, they will simply say, oh, yes, we are only Facebook India. We are only the non-exclusive channel partners of like Facebook Inc., providing their services here in India. The same was true with respect to Google, the same was true with respect to Twitter, and same was true with respect to many big tech companies which are operating from outside. The fact remains that if you are, as a country, if you are dealing with faceless entities, how will you get justice either as government or even as citizen? The rules were brought in. The rules were maybe were severely criticized also, but the rules have put in place a well-defined structure wherein these companies have been asked to have their grievance officer here in India, their presence here in India, some nodal contact person here in India, the compliance officer here in India, a monthly compliance reports being published here in India, a system to distinguish whether you are actually an intermediary or something which is being published by you. Because in between, even that was a gray area. And many more, I should say, such things have been created. It actually might have been presented well in the beginning, but sooner or later, they are also feeling the advantage of it, because everybody wants to work in a regulatory stable atmosphere where things are very clearly known. And from our perspective, we even introduce the concept of the grievance appellate committee, that in case, while the grievance period was reduced from 30 days to 15 days, and for certain cases, even for 24 hours. So they have all gone in a big way for the safety of the people. But in case the grievances remain unresolved, and there have been a good number of cases where the grievances did remain unresolved, and the people went to the court, that the concept of grievance appellate committee was also introduced. Those grievance appellate committees have already been constituted. gac.gov.in portal has already become operational. People can approach and can seek for an online grievance redressal mechanism, which is expected to deliver results positively within 30 days. Of course, the kind of response which we were expecting, as government, is still not there. In terms of the number of grievances, which we expected to be much more, it's not there. Hopefully, it will pick up. So anyway, so this is one area where we learned with the time. We changed the rules. We changed. Of course, we couldn't have changed the act, but we changed whatever which we could do through the subordinate legislation. New technologies, they keep coming, and therefore new threat perceptions, new risks emerge. Now, sometimes your act is good enough to be able to take care of such new risks. We per se don't really make the law keeping into mind the technologies. The laws are always technology agnostics, but risks arising because of these technologies is what needs to be perceived well in advance and should be taken care of in the law. Naturally,
Mr. Mashi,
Yeah.
I just want everyone to
Yeah,
weigh in
okay,
quickly, and then
okay.
I'll come back to you. Dr. Seth, so Digital India Act in a lot of ways replaces the IT Act. IT Act came into existence 2 decades ago. It was a very different place. The kind of obviously we didn't have as many users, we didn't have so many intermediaries, the variety of intermediaries. But one of the reasons that is stated by the government and also by the civil society is the kind of harms that are posed by intermediary now are nowhere close to internet what we had 2 decades ago. So in that context, because a lot of it comes to senior lawyers like you when you have to prepare the case and all, from a harms perspective, how much of a difference do you think when it comes to upholding digital rights of individual citizens does Digital India Act has the potential for?
Right, it's a very pertinent question, Jitanshu. In the current matrix of tech and law, this poses one of the most important questions we are all trying to address, both at the government and at the civil society, at that level. And when we look at the way, the basic principles for any regulation, whether it's in India or abroad, even in terms of the Digital India Act that you're talking about, openness, when we talk about transparency, safety, privacy, and accountability. These are the key, I would say, objectives behind every legislation which takes care of tech law, right? So here also the emphasis is on openness and transparency and accountability. When it comes to intermediaries, your specific question is on intermediary and liability and harms that may be posed. So accountability, we are trying to step up the accountability in the Digital India Act. And for that reason, there is a diversification. There is a segregation of what is the category of intermediary and what should be the rules for the same, because there are different kinds of intermediaries. There would be, for example, a social media platform. There could be even an app store, a Play
Correct.
Store. So can they escape liability only on the basis that, we don't publish or we don't post content ourselves, or we cannot do KYC beyond the basic primary point, So when it comes to even giving SIM cards, for instance, there is a there is a mechanism of KYC. So likewise, for the intermediaries who are, say, app stores, there have to be certain KYC checks. And that was the reason why, when fake loan apps were brought up, into the scanner, the RBI brought out a regulation. There were guidelines to say what parameters will be weighed and how the apps will have to be, compliant in order to be on the app store. So the harms which it can pose, not only can it be harmful for the reputation or for the data of persons, because through phishing, through certain software like keyloggers or other viruses or malware, a lot of sensitive data of people could be taken away, and that it actually is being taken away in many respects on the net. So if there is a KYC requirement, if there is a due diligence which is necessitated in such a scenario, it will safeguard citizens. And for that reason, it is important to have a separate set of regulations for that category of intermediaries. Whereas if it's a social media platform, the accountability, who is publishing, the content, whether it's a third party or it's being moderated, maybe there's an ad revenue generation, and that has been seen in US and other case law also, that wherever there is an ad generation, there's a moderation or even the ability to control content. Then in the terms and conditions, if it says that, the intermediary reserves the right, it may have also the ability, that is why they're reserving the right. And are they in effect actually utilizing that power? Are they exercising that power? That itself are, those pertinent aspects which will come into play to decide whether they actually have a control or no control, and whether they are a publisher or just an intermediary. So these intricacies of law, we can call them nuances of law, will have to be looked into, and regulation based on
not only the intention, the knowledge, and the ability to regulate, content has to be looked into. So from that perspective, I just, in a nutshell, would summarize your question as, the answer would be that these key principles will have to be kept in mind while a segregation of intermediaries is also looked into, and appropriate regulation catering to that particular intermediary and only to the extent necessary should be imposed.
Okay. Subodh can hear us, right? Can I see him on the screen, or is that possible? Oh, great. Can you hear me?
Yes, Chitranshu, I can hear you well. Go ahead.
Can you hear us?
Yes, I can hear you. Can you hear me?
Great. Okay. So, Subodh, because you've researched a lot and you also teach at IIT, away from the Digital India Act, I wanted to pick your brain about data localization, because whenever data localization is often shown and talked about as a fix. I don't know if you saw the recently the TikTok CEO was called in the US, and he was actually talking about how most of all the data of TikTok, which belongs to the American consumers, is actually hosted locally. In India also, it keeps coming up off and on. Here, the idea is that if the data is actually hosted within the country, it's unlikely to be misused. But the flip side to that is the government is never going to host or look after this data, right? It's basically being shifted from one tech company to another, right? So, for example, if in India the data is being hosted, maybe a company like Infosys would take care of it. The other flip side to it is, let's just say if we're dealing with a European company, and we say that as a country, the data should be hosted at our end. But from a user safety or from a user privacy standpoint, it's very likely that the European country might have way more progressive laws and legislation when it comes to data protection or user privacy. So if you could just tell us, is data protection really this black and white as it's shown to be and talked about, or is it really a lot more nuanced, specifically when it comes to data protection and user privacy?
Thanks, Chitranshu. Thanks for having me on the panel. First of all, hello to all other panelists. And let me straight away get to the question. The answer clearly lies in the question that you stated. It's the latter, right? It's not black and white. It's very nuanced. Data localization on its own doesn't mean much unless you have regulation, you have regulatory capacity to make sure that even when the data is stored locally within the perimeters of your campus or your nation, enterprises do not breach the purpose for which the data was collected, aggregated, and processed, right? So how do you ensure that? Because the moment data leaves the boundary of the data controller, there are no checks and balances. In fact, many times the problem with most privacy and security related properties is the fact that it's very, very hard to determine the causal links. There would be a privacy breach and nobody would know about it, leading to indirect harms like inaccurate inferences, exclusions from particular services, or predatory targeting of products that may not be needed by that individual user, right? So large data registries that are being maintained by big tech corporations and government, right? Both government also create and maintains large data registries. So in my view, data localization makes sense only when you have in law very clear articulations of what this data localization would entail. How would this data reside? How would it be processed? Will the entities clearly state the purpose for which the data is collected and then utilized? And whenever there is a purpose extension, will there be a specific request? So there cannot be a silent purpose extension. All such purpose extensions should go through a regulatory framework, and this regulatory framework cannot possibly be manned or created by government agencies. Of course, big tech companies or tech companies would have to assign their own regulators, but at some point they will have to, sync up with government agencies so that government agencies can actually educate, fix accountability, for which the government agencies themselves have to build certain regulatory capacity ex ante, right? So for systems to operate, this regulatory system that would be created should operate in a manner that all causal links to determine any security or privacy harms are detected ex ante and not ex post, because after they have happened, it's very hard to determine to begin with. So yeah, it is very nuanced. And just to get to the question that you had asked other panelists, there's no doubt that digital services and digitization has got great positives and has brought a lot of efficiency and growth in our economy. But I'll be cautiously optimistic about the Digital India Act, because I would like to see a whole lot more in the Digital Privacy Bill. For instance, how are you going to implement purpose limitation for entities who harvest large data, maintain large data registries, right? The devil is in the details. You go to Europe, well, there is this GDPR. You go to US, there is HIPAA. All of these privacy standards exist and privacy bills exist. And they would very liberally use terms like purpose limitation, but the devil is in the details. How are you going to orchestrate purpose limitation? There is no easy solution for that. I'll stop there. Thanks.
Thanks, Subodh. So I'm going to do, I'm going to crisscross, and Mishi, I would like to start with you again. Internet as a concept was designed as a free and open space, right? Where access was free. There were no restrictions. And the reason why I'm asking you this, because I want the audience here to be able to also see what's happening in tech policy space in India, visibly what's happening outside also. Increasingly, nation states and countries are enforcing their digital boundary as strongly as physical boundary, right? So you have the famous Chinese firewall. The Russians are building their own. Obviously, the Americans are looking at banning TikTok or whatever that means. So increasingly, there's a lot of talk about this. And in a lot of ways, that goes against the very principle upon which this free and open internet was based on. So what I want to understand is, do you think this was always inevitable to happen, where tech would become such a strong part of our society and governance that nation states and leaders will have a stake in it? So for example, what's happening in Taiwan with all the chip business and et cetera. So do you think A, if it was inevitable, or B, do you think that it's really a case of how big the tech has become, especially in terms of our day-to-day life and governing the society?
That's a lot. It wasn't inevitable. I will say one of the things which happens is that a lot of things were happening at such a rapid pace that the governments felt left behind. Mr. Maheshwari rightly pointed out that the revenue of some of these platform companies would actually encompass several countries at that time. And governments like power. They're not ready to give power. They also have responsibilities because they have been elected to do certain things. They have to carry out their responsibilities. However, the entire thing which misses from this conversation is that the people are at the center of it. People's rights, even for the Digital India Act, the fifth objective is protecting citizens' rights. First, we are making about accountability, various other matters, etc. When internet came, we all thought, and I used to laugh about it, that a lot of people, even in India, thought that they had First Amendment rights. India's First Amendment is obviously restrictions on free speech, not the US First Amendment, which means you can speak whatever you would like. But a lot of people, in the mistaken belief, because it really shut down the boundaries, thought they do have those rights, they can speak whatever they want, and there was a different aspirational promise. But then the platforms came. They wanted to collect all data. And one of the things which even we pointed it out, rightly so, they treated their Western users very differently from their developing country users. So if an Indian wanted to get some actual content taken down, there used to be all these problems. However, when and we would tell them that because you are not responsive, because you play this Lex Loci server game, my service is in California, I can't remove anything, you are going to invite something which is going to take away the rights of the citizens. And that's what we are seeing right now. We are always saying the collision between the government and the platforms always results in taking away our rights. We are supposed to watch from the sidelines as government decides, oh, the companies are not doing well, and the companies decide, oh no, we have business interests, but users are watching from the sidelines. So to your point, earlier I could speak very freely, now I can't speak freely online in the same way. Everybody has to watch out. There are different things which cannot be done in the Parent Act, are done through regulatory structures, which are subordinate legislation, where the power is expansive. So what happens is, it's not that the companies didn't have a role to play. They definitely made mistakes, which if they had not done and had a nuanced discussion, we wouldn't have been here. But that didn't mean that the government didn't swing the way they would like to exercise power right now. So where we have now become is a new kind of a social contract. In exchange for governments to allow these large companies to collect all our data, you collect all our data, you monetize us, you sell us ads, you make us whatever you would want, because internet has never figured out any other way to make money but surveillance capitalism. The governments will say that you will do censorship by proxy, you'll take down everything which we don't want up there. We will tell you this is misinformation. We will decide what is false information, or what is fake news. We will tell you to take this down. You will take it down. And earlier, the companies would pretend that they are the free speech advocates. They are going to connect the entire world and they're standing for our rights. Now they have folded. You would see the number of documentaries that are taken down, the number of handles that are blocked, the content that is taken down. Now everybody folds very quickly. And if they don't, they lose the safe harbor protection. And the users are wondering, so what really happened so quickly? And in terms of protecting our data and our rights, where is the data protection bill? It's not a panacea. It's not going to solve all our problems, but it was supposed to solve some problems. We still haven't seen it so far. And there also we are being told notice, consent, that model is broken. We all know. How many of you have ever read terms and conditions? I have. I'm a lawyer. I make money that way. But I also write them so that they're confusing for everybody. But people, that's why my view always is, when we are trying to talk about various matters, people protection has to be at the center of it. Many of us love technology. I want to share pictures. I also want to use various things which are making it possible for us to interact with technologies, but I don't want my internet to be suddenly shut down without any reason. I also don't want my website to be taken down because I wasn't told, or in name of accountability to say a lot of stuff has to be always informed. We are moving in a place where everything is exempt from freedom of information or RTI, but the citizen has to be completely naked and tell everything. Because if you're hiding, if you're not telling us everything, you must have something to hide, which is completely opposite of how we think about rights system. I think one of the most important things which Mr. Maheshwari touched upon, and of course, because Ashish has been doing this for so long, is everybody likes predictability of regulation. I think it's an important point. I also think very important point is to do away with criminal liabilities for corporations and businesses. So to say that whether it's the Jan Vishwas bill or otherwise, one of the contrasts I see in the world, and I have a law practice in the US and in India, is that the US relies on damages. So whether it is, there's no criminal defamation, nobody's getting disqualified for criminal defamation, but, or a corporation or a company executive will not be held liable because you post something on Twitter. That it will be a damages, it's a civil suit. That is a problem in India. We've all been talking about it. Once we do away with that, that's an excellent thing to do. After that, in this entire discussion, if users are not at the center and accountability is at the center, then we are not in that multi-stakeholder model. Then we are in the model of power matches money and you all watch from the sidelines. And that was not the promise of the internet. And that's why I started the remarks were, India has the talent. India also has the ability to offer this as a global hub of pro-IT humanity. America is never going to, the omnibus legislation on privacy, we've been talking for so long. Next year are the elections, nothing is going to happen. And Europeans are doing it the way they are doing it. We could have not only built the tech, we could have also come up with regulation which talks about privacy. But instead, we are moving in a direction where we are so concentrated on controlling the narrative, what gets discussed every day, who speaks what, how can we take down certain, that's not only IT policy. And that's why I loved what Ashish started with, the fact about optimism in terms of where we can go, or where we were talking about criminal liabilities. Another thing I will say is that just because some companies fail to act does not mean users are going to be punished. User-generated content, safe harbor are established principles. We are trying to do so much of the kitchen sink in these rules. Somehow IB comes in there, online gaming is also there, news, now you are also covered, everybody's covered. So that does make a user very confused about their rights. And then one wonders, where is the promise of that internet, where I could also start a business and I could also speak to anybody and I could also operate, interact freely. So on that uplifting note.
Correct. So Ashish, just picking up from what Mishi was saying in terms of predictability of law, and since you work with a lot of tech companies, I wanted to understand, because especially in the tech domain, a lot of policies have been happened, right? Like, for example, what happened with crypto. And I know you worked with the Ministry of Finance also a couple of years back. RBI came with a guideline on recurring transactions. And I know it was from a standpoint of like certain user privacy concerns and to take care of certain harm use cases, but it really sort of impacted any publisher or any organization that dependent on recurring revenue. I think to this date, even now the e-mandate recurring revenue does not really work. So a lot of times corporates are very wary of the policy and guideline because it hits their bottom line directly. So my question to you is, because you interact with a lot of these companies, yes, there are these two laws coming, but in general, there is also a lot of clamor about how companies, specifically tech companies, have been allowed to operate without any regulation. That does not allow to all the companies, but specifically tech companies, right? So for example, one day Google Play Store decides that we'll kick off Paytm, right? And a lot of it has happened because there were no regulation, because there was no guideline. So I just want to understand, when you speak with corporates, especially like tech companies, how are they looking at this? Are they investing a lot in tech policy? Are they skeptical of it? Are they very cautious about it? Or they're like, okay, we'll see when it comes and then figure it out?
So I think there are two ways of looking at this, and I'll try and do it without taking too much time. One is a very ground level view. When you are doing this, you are talking to government, you're talking to industry day in and day out, and that view might be a lot of confusion, a lot of challenges, and oh, where are we going? You try to zoom out of it, take a decade kind of a view. What has happened in tech policy in India? How have we dealt with it as compared to the world? And I think on balance, at least my view is that we've actually done quite well on a lot of fronts. So there is a lot of that process which leads to all this chaos, and we are always contemplating and worrying about the harm which will happen if the policy actually goes in the way the discussion is poised today, and then tomorrow, and then yesterday. But eventually, I think on balance, I think there is, you find that a lot of the things are not that bad. So having said that, and so from an industry point of view, they would love certainty. but you will never have certainty in that sense where, the industry looks at it. And I'll come to that again. And government wants flexibility. So government is saying, don't bind me to in a certain manner. I want to be able to bring the full force of the state on somebody who is actually misbehaving. Now, this is the problem. So when you translate that flexibility into a law in a manner where industry or the users don't have clarity either on how the law can be interpreted. So you're waiting for a court judgment at some point in time in future, and unless it's the Supreme Court, you're waiting for many court judgments. Or even if the law itself is clear, you don't have clarity on the procedure that will be deployed to implement that law. And I think that is the uncertainty that is worrying. So, and that we see in a lot of things. And clearly the IT Act has run its expiry date from that perspective, because if you take any of the larger issues, the intermediary, couple of sections deal with it, cybersecurity, one section tries to deal with it, clearly inadequate. We haven't had a country level discussion on cybersecurity, huge subject in a $1 trillion digital economy discussion, which we are talking about from a user and an economic, and hopefully in DIA, we should have that. And so who is best placed to have that neutral discussion? That is a question. Globally, we have seen regulators and agencies across the world who have gone through that process in that selected manner, and perhaps for better or worse, that process itself I find is little better. In India, like I mentioned earlier, you don't see a consistency in that process or a necessity of that process to be built in. And maybe Niti Aayog, I was thinking, is a good place. It has a PMO cover, it is neutral, it is away from RBI or MeitY or anybody. It has done some stuff on AI and thinking, but very high level. If it can, something like that, if it can actually present an assessment of what has IT Act actually failed and delivered on, as against a NASSCOM report or some civil society report, because likely to be taken differently, right? So I think that is the process to then have a discussion. And I want to highlight 2-3 things in the context of the Digital India Act. A lot of Digital India is about government. It is about government citizen services. It is about government, and when I say government, I'm talking about the state. So 20 years back, internet was new. So somebody was offering something digitally nice to do. So nice, there is an IT ministry. It has come out with a good initiative. MCA has done something wonderful, good to have. But now it's like water and electricity. So why is it that, for example, a UIDI should have a mandate to revisit all its citizen-facing interface and digital services and make sure it is world-class? It can't be that people are struggling with some aspect of that service, for example. And similarly, a lot of other services. So can Digital India Act also focus on the government and say that all the services which now are citizen service facing or regular, so data, I look at report, somebody puts up a PDF, somebody puts up a circular in some format, somebody doesn't put up where any information is. And then there are consultants and lawyers who make a lot of money because I understand India's FDI policy, because nobody else otherwise understands. So I think just simplifying everything, providing everything in machine readable, local language, all of that. Consultation process, what do we mean by consultation? It is not about you have listened to me and you have thought about it and you have decided. That is not consultation. Consultation is, I said something, you responded, we all came to a logical agreement that we could have a disagreement, but you have this point of view and therefore you went forward. We don't have that consultation. So if we don't have that consultation, obviously there is worry that what might happen in the law, and then everybody frets and comes up with all sorts of scenarios which are not real, which even the government is not intending anyway. So I think I'll take a look at third direction. This is an example of compliance requirement and technology, technologically what can be done, not possible. You want KYC to be verifiable. So I am an industry. I can ask you, please give me your PAN card, Aadhaar or whatever, but I can't verify that whether your house address is the same address which you are actually living or which is in the card. I can take an indemnity from you, but a verifiable KYC means I will have to go to your house and verify you are actually living there or not. If I'm a cloud service provider, why should I do that? Anonymization and anonymity is an important factor on the internet. So why should everywhere KYC be required? Sometimes anonymity is good. When you say a false statement, satire is false, jokes are false, stories are false, they're all fiction. We can do all of that on the internet without, I can call myself instead of Ashish, some magical name and have that magical life on internet, right? for a very reasonable purpose. So linking anonymity to harm is important. And I think in a lot of this, this also leads to the fact that you have even if you have a great law, you won't have, if you don't have enforcement capability, it is probably very, what do you call, suboptimal outcome. And one example of this is traceability. We wanted, in case of a WhatsApp scenario, that we should have traceability. So it has been a year. Is there a report which says that we implemented traceability? This is a study which shows that this is how this has benefited the state and how many people we have caught because of this. Because at a very basic level, and I'm not from IIT, but Subodh can maybe tell us that there can be so many false positives. And what are you talking about when you say traceability? Because if I have got something and saved it in my photo and then forwarded, then I'm the originator. So, and it puts a liability on the industry. Policy folks are debating about it for ages and man-hours. So I think that capability to say that we are dealing in a little more complex world of technology, and we need to invest in understanding. And once we take a decision, we will also be accountable to that decision. And as a digital government, we will focus on ourselves also. Consultation process is a blind spot. We are doing progressively better, but we will actually need to do a lot more. And to Subodh's points, for example, data localization. So for example, has somebody done a study in India from a government side to say that how should we look at data sovereignty? What is the data where we would like sovereignty? What levels of data sovereignty are useful? And let's have a discussion at an India level, as a whole of government level. SEBI has come out with a regulation very recently saying, if you are outsourcing to a cloud service provider, that cloud service provider has to follow MATI's empanelment guidelines. MATI's empanelment guidelines are for government vendors. As a merchant, government can ask his vendor to store the data locally. Now, cloud saying that all mutual funds who are outsourcing somebody some service to this thing, this is like, I think we need a huge amount of capacity building, and CERT has not changed the direction. So because government also gets locked in, now I've decided this, for me to retrace is not so easy. So this agile regulation making in that sense becomes complex. It is good if the government can also quickly backtrack and say, okay, fine, we did this wrong, we are happy to start all over again. Like industry, when you ChatGPT is launched, something is launched, as soon as Italy government has blocked it, it's given 30 days, they will fix it probably because they want to go ahead, right? So from a government point of view, that kind of process is lacking. And therefore, while we are very optimistic about it, I think you can't blink and miss. So you have to be on your toes, you have to participate, you have to say your point of view, make it work. And that's the positive thing about India as a democracy, that we might not like something, but we can actually change it. Nobody will, at least not, nobody will send me to jail, but nobody will send, I hope, anybody to jail for making it work. So I think that is the good thing, and that's the source of optimism.
Correct. Thanks, Ashish. I think as someone who works with the newsroom, I don't probably don't share Ashish's optimism that if the government pushes something wrong, they'll retract it. We had demonetization. But anyway, so Dr. Seth, I want to come to you. Ashish talked about the IT Act having run way past its expiry date. I want to talk about the recent amendment that was made to the IT rules. For the benefit of our audience, I think on April 6th, if I have the date correct, a new amendment was notified. The amendment is basically that the government gets to decide what's true or what's not true. So if we, as News Laundry, we put out a report on the Agriculture Ministry, which the government doesn't agree with, they can ask the social media platform intermediaries and telecom operators to block our story. And I actually have the statement that Mr. Rajiv Chandrasekhar gave, who's the Minister of State. He says, only the government has access to government data, and so it is almost impossible for any non-governmental entity to effectively fact-check content about the government. So I think this is a brilliant statement because it answers a lot of questions that the civil society and media organizations have been raising. And the backdrop to this is that we had IT rules 2021, where also the government had sweeping emergency powers to block any content. A lot of newsrooms have gone to the court. In fact, the Madras High Court gave, I think it was with Live Law, where they said that no action will be taken against them. So Dr. Say, I want to, from a layman's perspective, I want to understand how is this working, right? Because you already have petitions in different courts. The government already has so much of power, and then we have a minister who says this. So I'm not going to ask you to comment on the minister and put you on the spotlight, but like, what is the legal logic to it? Like, or is it that we'll push it because we can?
Well, again, freedom of speech, as we call it, freedom of press, it's been sacrosanct like throughout, like if you see the time we got independent and how the whole judiciary also, the courts have upheld the rights of citizens to speak up their mind. Even the press, they are free to report what is true and what is in the citizens' public interest. If you look at our legislation, if you look at even defamation law for that matter of fact, if you look at the IPC, it's very clear that's a clear exception. If press is reporting something which is true and verifiable, then that is an exception to the defamation suits also. So with that logic, I think our courts and our regulations so far has been very, very clear that unless there is a reasonable restriction is only levied on those counts where there are justifiable grounds. Our Constitution of India, when we talk about Article 19, particular 19.2, lays down those limited grounds on the basis of which reasonable restrictions can be laid down. So whether it's national security or national sovereignty involved or friend relations with other states, public order, decency and morality, and so on and so forth. So those are the justifiable grounds. When it comes to data, when you talk about tech and data, then yes, when a press is reporting a particular news, right? Press is reporting something which is in the public domain, for instance, something which is to do with an enterprise or a policy or a citizen's, action, then they are free to check their facts and report. Likewise for government also, if there is, something which is a matter of importance that needs to be reported and can be verified to whatever extent the material is available, the facts can be, accurately reported in that, right? So there is freedom of speech. Whenever it comes to, things like RTI, for instance, if you've seen, there is a particular clause which says certain data will not be shared with citizens. Likewise, certain data may not be in the public domain or may not be, something to do with, for example, national security. There are files which are not available to citizens or even to enterprises or to press, for that matter of fact. Certain information may be classified as completely confidential. Now, in that regard, yes, that confidentiality needs to be maintained in the public interest again. So you have to balance the scales. Whereas if it's not something of that, I would say that's kind of requires that kind of secrecy or standard and can be shared again in public interest, then it should be shared. That is how I look at it, So it has to be reasonable, it has to be fair and justifiable. I don't agree with this fact that there would be unbridled powers and unjustifiable powers, that take away the freedom of speech. That is something that I will be very clear on. That's my personal view. However, I also understand that there may be certain information which needs to be kept secret, again, in public interest, and for that matter of fact, cannot be shared with press. So if a power is given for fact checking, for example, to PIB or to another authorized agency to check and verify whether this is true or not, as a fake news or not, that to that extent can be justified. However, if it is not objectively verifiable, if it is not objectively fair, and in the standards that we follow under Article 19 and 19.2, then it falls foul of the law. That won't withstand the test of law.
Okay. Subodh, I want to come to you, and I would like you to weigh in on the digital divide. Achha, okay. So, Michelle, I'll put this question to you in that case. So I was just checking yesterday, we have more than 1,000 apps in our country, and these are all government apps, right from apps where Manrega workers have to upload their attendance, to Aadhaar being compulsory for midday meal schemes. And what has happened in India, especially with the Prime Minister's push to Digital India, a lot of social security is being linked to the digital infrastructure. And obviously, a lot of us, especially us in media, we love to talk about how internet and 5G has reached to remotest part of the country. But the truth is that we still have about 400 million people who have access to no internet. Moving forward, the government has plans to link more and more social security. We have something like Health Stack. And obviously, between all of this, Manrega workers are protesting against their attendance being compulsory, having them to upload it on an app. So my question to you is, as civil society, how can government make sure that even though we are rapidly digitalizing all our social security, how is it that people who are actually on the margins, people who are in remote parts of the country, right? For example, if you're a Manrega worker, which means then you need like at least a 15,000 rupee smartphone, right? Because a regular smartphone of 3,000 or 4,000 rupees, you will not be able to access all these services. So do you think as civil society, A, are we putting enough pressure on the government? And B, as someone who understands technology and is a technology lawyer also, do you think there's a solution to it? Or there will be people at the margins who will be left out and we'll have to make peace with it?
So this question is for the person on your right, not on your left.
I'll come back there.
I mean, I'm not government. I think they're better, but whether we are putting enough pressure on the government or not is, what I'm going to say is that, jokes aside, I'll defer to what Ashish said in terms of the consultative process. It's unpredictable and not agile enough to borrow from his terminology. I think there is definitely enough of pressure being created to only ask simple questions. That tech's idea, and if we are going to use and move a lot of public service provisions to technology, then you also have to ensure that it reaches the right recipient. Now with Aadhaar, we've seen a bunch of other problems. We've seen a variety of issues which are created, well-intended. It's not that always that the idea is not correct, but the implementations are different. India is a large market. We don't, right now, 900 million plus people have feature phones, but smartphones is perhaps much lesser than that. People will get there. Now, accessibility, that's why has to be inclusive. You cannot say we are moving everything online now. I will say my father-in-law passed away in COVID during the 2021 Delta wave that happened. One of the problems which my husband's family faced was that he had not created a digital signature. He had a business on his own. We could not get anything moving. Now we were told everything is digital. You cannot do anything. We cannot operate a bank account. We cannot get rights transferred. He had a will, whether it is probating it will or getting, everyone told her everything is digital. My parents are senior citizens. They have a ton of difficulties operating a variety of things which have gone digital. That's not true for a variety of a younger people crowd. So now when policies or when things are being forced, we do have to account for that. Access is a problem. And to your point, somebody who's in a remote location, you decide to shut internet down for 4 days, but you say everything is now done online. Please, tell me how a person who's hand to mouth, whose business or money is stuck in a smaller thing, how are they supposed to operate? That is why when we do internet shutdowns part, one of the things which SFLC does is collect human stories, because it's much easier to do empirical stuff, to say $1.5 billion lost and this person is not working. But it's much different to understand that somebody sells fabric on WhatsApp and they make 8,000 rupees or 10,000 rupees a month. And somehow they can't operate any of that because they just don't have access for 4 days, 5 days, makes a difference. So to the example which you quoted, I would say that many of the tech is well intended. The desire is right, but we are told these are teething problems. A lot of people suffer in your teething problems, and it's a matter of life and death. It's also a matter of how you fix those problems, and why would we take away the offline provisions while we are implementing a system is somehow which baffles me quite a bit in that sense. To say again, civil society, our only view is
why do we all exist? Why does government exist? Why does industry exist? We are all here for the society and people. If we move outside in and then we at least are clear of the fact Aadhaar is created for a purpose, KYC is created for a purpose. Are we serving the people who actually require it, or we are trying to do certain other things which fulfill us? I would say that that inclusive policymaking, inclusive implementation of those policies needs a lot more than we are doing currently. But that's not to say we can't recognize the good that has happened. However, as people who work in these areas, we always say, okay, great, this is all great, this is good, well done. But now our job is to recognize what has not happened. And that's why when you'll talk to me, you'll always find there are problems which we are talking about, but that's just comes with the territory.
Sure. So I think one of the things is, you will all, and I think the entire digitization has actually brought access and services to a lot of people, right? So that's the headline message. But what we miss is this entire thing of, debugging and looking at what is not working. And one of the tools, at least some regulators have used, not so often in India, is the idea of mystery shopping, where you set a group of people out to utilize the services without revealing that you are regulator or hired by regulator, and then bring back a report to the government to say that, what is working and what is not working. So if just more and more government agencies and regulators did, contracted mystery shopping exercise, there are agencies which do it very well. I think you can fix a lot of this stuff because there is an incentive alignment to fix a lot of these things. So it's just a matter of doing some
correct stuff. So Mr. Maheshwari, you're the only one on the panel who's been on other side of the table, so to say. So if you could weigh in on the digital divide, and these are, like I said, the Digital India push is not new, right? It's been there since 2014, since the current Prime Minister came in power. In your experience, in your work, has the ministry or have you and your team dealt with these questions of accessibility that, okay, yes, we want more and more people to use social security linked to a digital infrastructure, but also let's think about people who will not be able to do that?
These are genuine questions in any developing society. And I completely agree that one, of course, the intent is good, and two, the implementation may not be always good. And to that an extent, we must try to, get insight of what is going wrong and how it can be corrected. And to that an extent, I know with respect to the processes that I have dealt with, one of them, for example, happened to be a 69A process, which dealt with blocking, but those of the organizations with which we have dealt with, they will all vouch for the level of transparency that we maintain, which does not mean that everybody needs to know what we are doing, but definitely those which are interacting with us, the way we are interacting, the logic which we are following, the logic which they need to follow, everything was transparently done. So once again, I'll just like to mention the intent. One, the intent should be good. Yes, there should be a willingness to move back if required. And that's what has happened in our processes that we have followed, at least I have followed while being in government. And three, learn from these opportunities and once again move ahead. So in terms of accessibility, maybe the kind of costs that we had either in terms of, say, the mobile phones or in terms of internet accessibility, all of this has substantially improved. And if the same trend continues, hopefully, it's not that once again everybody will be covered. It's all said and done. The digital divide does increase or has increased, but then that does not mean that progressive steps should not be taken. Yes, of course, you should also be having such processes in place to be able to cater to everybody. That's it.
Dr. Seth, I would like you to weigh in on data stewardship model for courts. So courts also process a lot of data, right?
Oh, yes.
This includes both personal data and non-personal data. I know there have been a couple of proposals as to how all this data can be centralized, and not in a way that where private law firms can make use of it, but like the judiciary can make use of it to sort of draw, to look for legal patterns and also look for information that can help setting up certain constitutional benches. So is that a subject that the legal community has talked about and looked at? Because that's a very important part of data protection and data processing.
Yes, absolutely. Data of citizens, especially when we're talking about access to justice, we currently use even the e-filing processes. So there is a lot of data which people file as part of their matters, and that is something that the courts have to look into their confidentiality. Certain data which we file in the courts is also in sealed covers, which could be even devices. It could be even in a soft copy or a pen drive. So data, therefore, in the courts is as valuable and as requires secrecy or confidentiality as, for that matter of fact, any confidential information in an enterprise or even civil society or otherwise. So that is goes without saying that judiciary is being digitized. The whole process, the e-court systems, we have currently worked a lot on that, and more than 10,000 district courts and 21 high courts already have available a software by which citizens in rural India as well as urban can file their petitions or their cases. So that's a big achievement. Also, we use technology in courts today, whether it's virtual hearings during COVID, and it's still continuing. We are in the hybrid mode. And not only that, live streaming of court proceedings. There is also digitization of case records, even judgments. Our Honorable Chief Justice of India, Justice Chandrachud, is very, very, I would say, passionate about using technology in deploying, new tools and techniques, including AI, for that matter of fact, how that will really achieve the milestones we wish to achieve and remove the backlog of cases that we have today, and protect the data as well. So we are already working on even electronic evidence rules, where how electronic evidence will be filed in the courts of law, and the data therein, whether it's devices or it's mobile phone or any gadget somebody wants to file, how that will need to be done. So there are different levels of committees and different work which is already ongoing in that sphere. The technology is not only being deployed. I would say that our courts have upheld the rights of citizens also, and has been progressive and quite positive in protecting technology and, the growth of, I would say, citizens' rights also in this domain, because when we talk about right to be forgotten, for that matter of fact, or, you take up any other rights, like you had the Shreya Singhal case, if you recall, Section 66A was struck down, again, to uphold rights of citizens, so freedom of speech, right to be forgotten, and whereas other data privacy rights, we have Justice Sri Krishna Committee Report, which came, Puttaswamy case. So if it is technology, we are not only trying to adopt it in the way we function and making it more efficacious, but as a whole, the mindset, the perspective, the outlook which is there in both the legal fraternity as well as the judiciary is to assist and accelerate the deployment of technology, while at the same time balancing rights of citizens. So as Mishi had already, she was pointing out that, we cannot miss out, the regulation cannot miss out this angle of protecting rights of citizens. I completely agree with that, because we are actually creating such a regulation which takes care of this as a primary object. Why? Even in the Digital India Act, we have provisions which take care of not only fake news, but issues which have just emerged, like trolling or other kinds of problems which were not there at the outset when IT Act really emerged. Cyberbullying, extortion, there are new issues which are emerging. So those are also being taken care of at the regulation level.
Correct. I think we're almost out of time, but I'll just slip in one last question, and Ashish and Mishi, both of you can take it. There's a lot of interest in something which is called the India Stack. For our audience, India Stack is essentially a bunch of open APIs in digital good that can process three things from what I understand. One is identity. So that mostly happens via Aadhaar authentication. The second is payments, which is UPay. And then we have the DEPA, which is the framework for data processing. One thing is, because from a policy standpoint, there's a lot of interest to take this so-called India stack to a lot more countries. One way to look at it is, does it mean that inherently it will bring a lot more transparency? Because as you go to other countries may have certain expectation in terms of data processing, data protection. So A, does it lead to more transparency, or am I being way too optimistic here? So Mishi, you can tell us from a civil society standpoint, and Ashish, you can tell us how are the companies looking at this India stack, right? Because it also opens a lot of doors where you have a basic digital infrastructure, and top of it, you can build a lot of digital services and products.
So I think it has been about 8 odd years since UPI came in, and we have had a few iterations, right, in terms of thinking about a digital public good kind of a model. And the latest being now we are looking at ONDC becoming it's actually a protocol in that sense, somewhat different from what NPCI has done. I think where there is merit in is to looking at it, to say that instead of every time thinking of them as initiatives which can spring about without any clear regulatory framework around them, to now saying that we have now matured somewhat to say that we can articulate certain principles in the law, that when we are looking at a digital public infrastructure, this is how we will make them more trustworthy and reliable and accountable. So I think that is something which the Digital India Act can consider. We believe it has to be a horizontal law. So if the consumer protection rules apply on e-commerce, and then how do they apply on ONDC model? It's still a bit of a mystery based on whom you talk to and what you are interpreting them to think about. So I think once and that's an internal thing that we need to mature with. But to your question, I don't necessarily think that these are two related things, that if more countries adopt it, does our system become better or worse? I don't think that's true. But I think it's a huge opportunity to say that we don't want across geographies to have technology lock-in, where India has implemented something very siloed, and Europe has done something different, and America is going its own way. So we may not have complete convergence, but we definitely can benefit from interoperability and coexistence. And that's something I think can help in when you think about identity. It means people movement, it means ease of doing business, and a whole lot of that promise. So I think that is a great opportunity, and there India is in a way taking a leadership role, and we are in the G20 presidency. And what we're hoping is that in this presidency, that idea has been seeded at G20 level. They have actually seen DPI as not a developing country need and a developing country solution, but something which fits in a global use case. And now I think the next two presidencies should see that that entire journey, where we will probably see this kind of stuff happening everywhere, not necessarily in the exactly same manner, but with these principles of coexistence and interoperability.
Correct. Mishi?
So, I'm a little confused by the question, but when I see India stack, there are elements of it, of course, which are useful and perhaps fit in some kind of a requirement in other countries as well. However, the first time I thought about India stack, and when I was talking about it, my first meeting, 2008, Eben and I met Mr. Neil Kenny when he was trying to do Aadhaar, actually. That time, India stack didn't exist. The idea was to use free and open source software underlying. That's my background. I always have talked about the fact, and this also speaks to what Ashish is talking about, kind of a vendor lock-in. When the building blocks of everything are open and transparent, and we know what code goes in, then we can go and look and analyze the code, and we actually understand what's going on. We were promised that it would be those elements. So We haven't seen that happen. In fact, there's a lot of discussion being that open source means something else, which is a little surprising to me, because I know that the definitions are established, the license structure are established, the entire world works around that. Microsoft spent billions of dollars buying GitHub for that, and we are all, so there's no argument here. But if you want to pretend to say something which doesn't mean, then there's the problem. I think where perhaps you're alluding to is that there's never a problem in terms of understanding that a tech has certain building blocks over which you can build something and provide a certain kind of services. And it might serve the need of several countries. When we travel with this new passports these days, they only just swipe the passport to get a lot of information. And that helps in how people move from one country to the other. The problem here it is that when public-private partnerships happen or something is outsourced to a private party, and there is no transparency behind it, and then government collects data and then hands it over to certain fixed parties without the public knowing exactly who are these parties, what is the structure regulating those parties, what are the elements which are going underneath, that's when it raises questions. And I think something which Mr. Maheshwari and Ashish had pointed out earlier also, sometimes the reality may not be as bad, but if you're trying to do things in secrecy, people are going to speculate. People are going to doubt what is going on and what is underneath here, and how anyone who challenges something is presented, it makes a difference. We've seen Aadhaar has had issues. We don't have data-centric security in India. Our cybersecurity models currently don't work. Data breaches happen every day. They don't even make front page news these days. My day job is to work in a cybersecurity firm, working very closely with the federal government to understand what their requirements are. We see that those policies in Europe, we currently are not operating in a zero trust data centric requirement. So if somebody asks you a question, how are you protecting Aadhaar data? One day we are told you can share your Aadhaar number with everybody. The other day you are told, please keep it to yourself. The third day it is voluntary, then it is mandatory. I think those are the kind of issues which just unnecessarily raise questions. And to again go back to Ashish's point about if you make a mistake and if you're agile enough, you don't have to say we have 10 feet walls which are high to protect that data. Nobody's buying that thing. And that may be a joke in the courts. I can totally understand that part. But if you can just say that the citizen has a right to ask the government that, how are you protecting our data? Please tell us. What are the open source elements which go in this India stack? I had heard also that there's manufactured consent. You can, if there's no consent, it will be given, and later on you can get an audit done. And if any of you, if you've ever participated in an audit, indemnification provisions you've seen, or you've done even an RTI, it tells you a big picture. So again, when we question, the idea is to get those answers there. And it's not to say there is a problem. There might not be a problem. It might just be simple. But, and the second point which you asked about is, I think India has done a lot of work in services. There is a reason that most of the CEOs are Indians in tech companies. So the world, when we do something, does look at us, and we've leapfrogged into many of those things. So the learnings can be useful, whether you do it through G20 or some other fora you do it. But we also have to recognize that our rights-based infrastructure is not strong. And restrictions on free speech does not include anything false or free speech. There are categories which are clear. Everything is not security of state. And that structure will not translate into Europe. It will not translate into US. However, some good elements, why not? Why would they not take it if they are good? So I don't know what will happen. I do think that it is good that the conversations are cross-national, but I think currently India Stack itself has not lived up to the hype by answering the questions and concerns which other people are raising.
Great. We'll now open the floor for questions. I hope the diverse viewpoints on the panel help to make sense, because a lot of these are complicated subjects. So at least what I was hoping, that if we bring forth a lot of different subjects that are still interlinked with each other in terms of digital governance, it will nudge and push a lot of people to go back home, look these things up, because this is not something that should be just a domain of like a technology lawyer or a policy firm that is looking at tech. So yeah, please raise your hand if you have any question. Please state your name and whoever the question is for. Please try to keep the question as short as possible so that we can take as many as possible. Okay, either then we made a lot of sense or I did a very bad job of this. Yes, please go ahead. Yeah. There is a microphone. Yeah.
Hi, everyone. This is Preksha. Really good session, honestly. So don't doubt that. My question is actually related to consultations. When we talk about any such bills, and Mishi's rightly mentioned that any such provision in the law needs to look at user rights. We really need to be careful that we're trying to explain to the user, hey, this is what we're trying to regulate, or this is how it is in your interest. But when I look at consultation processes or probably the promise of consultations, I see that we lack there a lot. We talk a lot about inclusivity and getting the user in the conversation, but I honestly don't see that happen except for a few stakeholders in the whole argument or rather discussion. How do we change that? I mean, is there a way out of this situation? Because neither do I see probably all these wonderful bodies that we have out there who are working towards user rights, data protection. But eventually, we're a bunch of people who are just representing the voice of what probably people might think. How do we make people actually realize the significance of these legislations and how do they affect them? If you'd like to,
Who would you like to take the question? Or
I'd actually keep it open, but probably Mr. Maheshwari can actually be really right to.
I mean, I can quote only one example, a positive example. We published the draft of intermediary rules in 2018. Whatever comments were received were also put back on the internet. And probably even the counter comments were put up. So nothing was left with us, which is with us only and not with public. With respect to the other consultation processes, sometimes we realize that maybe people don't open up if they know all that which they are sharing with government goes back in public. But the way the consultation is done, the amount of time the consultation is given, and it's not just about putting things in public domain and seeking comments. At least in the near past, many consultations have happened. Of course, we cannot consult with everybody. We can only consult with we feel, or maybe which many a time. I mean, though the consultation is well announced through tweets also. But then I do agree, not everybody probably we are able to reach out, but we try to reach out as many stakeholders as possible. And in all these consultations, particularly, I mean, the Minister of State, our Minister of State at that time, Mr. Rajiv Chandrasekhar, at that time, I'm saying because I'm out of it now. I mean, he has led it from the front. So questions have been taken, responded to, and in fact, in the very recent amendment, which has been carried out and published on 6th of April, particularly with respect to the online gaming, at least 4 rounds of consultations did take place, 2 before the draft was put up, 2 after the draft was put up. And in fact, most of the expectations that were there have been incorporated. I don't say all of them have been incorporated, as mentioned by Ashish. I mean, not that, yes, we may have reasons to disagree, but then they have been incorporated. That's how the consultation process is defined in the government. Put it in the public domain for a definite period. If required, go for extension also. Maybe that's all.
Even I'd like to mention one more example. Just recently, we had this discussion, public consultation on the Digital India Act also in Bangalore. Right. So there also, we saw the Honorable Minister being there, and he was taking questions from the audience. Some were from, represented, most stakeholders were part of the consultation. Some joined virtually, some were there in the physical mode. So we see that there is a lot of active participation. It's not that, such discussions are actually not just one discussion, but there will be layers of discussion. And therefore, not only those comments, but also the ones which are, mailed across maybe or sent across by public in general would be considered in the various rounds and internal and external deliberations which take place. So that's a very clear and transparent and open way of actually engaging with the audience and the public, and, evincing their views on what they feel about it. And if they have clarifications they need or any apprehensions, they can, freely discuss. And I saw that it was very, very effective. And I was part of the consultation, and Mr. Maheshwari was right there. And we were given an opportunity to directly, express our views. I think it's a very promising sign.
I chime in too on this. Sure. So it's not a matter of empty glass or a glass full, right? So it's, I think we do have a consultation process and all that. I think, so it's also a very time consuming and energy sapping exercise in a country like India, where if you call out for a consultation, you will get humongous responses, right? Not all of them easy to make sense, because I've been part of the process at back end where I've worked with the government to help sift through consultations. So one, it definitely requires capacity. So if you are going to be doing what METI does, and if you don't have capacity to actually do this consultation management, then your first will be, okay, let's talk to 10 people who we think are sensible, and we have got somebody analyzing this. And if there is something useful in that, please tell us, and we go ahead, right? Broadly. The second, and where we want to push the envelope, which is the half empty glass, is to say that, okay, if you have got X number of comments which are talking about a certain thing which you don't necessarily agree with, then at a summary level, recognize that we got these 3-4 inputs, we have thought about it, and we have decided not to do this for ABCD reasons. I think that kind of a conversation is what will satisfy people who are participating with all that energy into that consultation process, because clearly there'll be people who will be happy, who will be not happy, which is fine. So, but I think that requires a lot of effort and energy. And sometimes that's a blind spot for the government, that why should we have the obligation to say all this? Why should we have to do all that, right? We are going to do the right thing for the country. And in their mind, they're right. They are doing it because they think it is right, right? So I think that's something to push for.
I'll only add that I've only run one consultation process in my life. That's the GNU GPL v3. It was an international one where a lot of big tech companies participated and a lot of nonprofits, everyone participated. I think there are enough software enabled consultative processes now where what Ashish is rightly saying, you identify one provision, you can actually go examine why, who, what has said, and then give an explanation. I will totally agree that we have to get out of that mindset of one party is superior than the other party. It is all multi-stakeholder does mean everybody does have the same weight and power to talk. And software now makes it possible to do it.
I think on consultation, I'll be the contrarian voice on the panel. If you ask news organization, I think they'll have a very different answer. I think in a lot of situations, there is a question of intent also. So for example, the very amendments that were notified on April 6th, DigiPub, which is the largest organization of digital-only news organizations, we actually wrote to the government saying how it is problematic. We never heard back. Earlier also, when there were amendments, we hardly heard back. In fact, in a lot of consultation processes, while the guidelines were being made for digital media organization, the publishers who were part of the consultation were legacy media organization. So there is, I think there's clearly a question of intent. There's also a question of who we want to talk to and who we not want to talk to. And that is very blatant and obvious to see whenever there is anything related in terms of framing guidelines or frameworks, specifically for digital media organization, because a lot of questioning, a lot of criticism is coming from that space.
So maybe at least the reasoning engines of AI tools can help solve the drudgery part of it. So if you want to just go through 10,000
By the way-
consultations.
By the way, the 6th of April rules wherein a section or some amendment has been done in one of the sub-rule relating to the fake news, and that's where maybe our colleague is coming, is actually not meant for media organizations, but for users, putting their contents on the social media. Yeah, so that differentiation has to be done. And yeah, so you are right. If you are having presence on internet, it can be, I mean, from the way government looks at it is in terms of two possible ways. One is you are having a presence on intermediary, or maybe you are a publisher. For publisher side, there are different rules, and for intermediary is what this consultation process was there. And as a media, you can also be on any intermediary. You can also be on social media, and therefore you are like a user on a social media. And to that extent, yes, these guidelines do apply. I will only request, because the only example that we have in the country as of today is the PIB fact check. Please have a look at maybe 1200 plus kind of facts that have been checked by them as to, and conclude of your own. I mean, so let's not go by what we are saying, what you are saying, as to if the information which has been, say, for example, labeled by them as fake, misleading, was it sort of pro-government, anti-government, maybe with a specific agenda, or was it really useful to a citizen? And maybe give us the feedback. Please have a look.
You have a case in point also with this media one, case which has been discussed in the press. And I think we can leverage technology, including to curb fake news, and it has to be objective. The fact checking itself is an objective exercise. So, it has to be done in the right way. We can use technology today. For example, things like photo DNA hash mechanism is being very effective tool to stop duplication of content which has a hash value and which is objectionable on the net. It has succeeded to a great extent. Social media giants already use the same. Similarly, I think not only AI can be used for consultative processes, as we were just discussing, but AI can also be leveraged to curb fake news. So the aspect is not pro-government or against government, or the news, how it is, whether it is true or not is what is the question. After all, you're fact checking. So keeping those balance of scales in the right order, we can deploy technology for objectivity purposes. That's what I feel.
I do want to say one thing about what Chitranshu said. I don't think it's a matter of balance, actually. I think we're all just there's a lot of contention about who are the right fact checkers here as well. We've seen that some fact checkers have been treated in a very different way by the state, and that creates questions about what is it that independence means here. And those are discussions which perhaps must happen. They're good discussions to happen. They must. But to your earlier point, the why you created that, I was thinking about when the internet.org or network neutrality discussions happened, and how we all actually had so many people weighing in to simplify those matters. I think because on the other side, it was Mark Zuckerberg. So it was all fine. It was great to do it. Right now, to always, those objections are not taken in the same light. If it depends on who you are objecting to and what you're talking about, but to simplify that process is important. And I don't think whether Mr. Maheshwari or what Ashish are saying, it really saps your energy. This is a lot of time, energy take, but ultimately it's impacting users. When you tell a user your favorite OTT thing is now there are TV series which is going to be taken down, or you will not be able to actually speak something online. Then they understand what the rules are. And then they at least have a say in it, which we don't do right now. We don't have the wherewithal. And even organizations like ours who try to simplify all of that, we don't have the resources to do it. And if it doesn't happen, that's why I said a lot of stuff happens in these tiny details, boring words, etc. But it takes time and energy, and we don't do that. And I don't see efforts also to build that kind of capacity.
For example, any kind of law, I remember when I worked with the telecom. So when I was happy to know that I was analysis, I tried to speak out so their voices and put out the analysis. So when I spoke to people, let's say even my own parents or my own sister, you know what, this has come out. Now that was maybe 200 word piece that I was very proud of. But to them, it was something that I did that, probably did not make as much sense to anyone who wouldn't, a non-technical person actually reading it. That bothers. Because that legislation is eventually going to be equal whether they understand it or I understand it better or they understand it worse. So I think putting the user in that process, that's the way.
I think media has a lot of responsibility there to decode and simplify a lot of these things. I think in general, newsrooms do a very bad job of this. Because again, a lot of these things are then linked to the business model and what are the kind of subjects newsrooms report on. But I think this is a responsibility newsrooms should actively take. The kind of interest, the kind of interest we show to just like quote verbatim politicians' bites. Sorry, we have to show the same kind of interest to simplify matters around digital governance. Yeah. I'll save the pay to keep news free appeal since this is not a news laundry event. But I'm glad we've made that point. Do we have time to take one more question? Should we wrap up? Okay. Is there any other question? Sure, sir. Yeah.
I think the point that Ashish made about the fact that the consultation, the processing of inputs into consultations seem not to show any engagement. That is the point I hear Ashish making, which is that you're not saying this is why we agree with something or we disagree with something, etc. But a question that has bothered me a lot, because I've been involved in a lot of consultations, is really routinely you find that the questions that are asked in consultations seem to be, at least half of them seem to be quite irrelevant, and quite routinely questions that are on everybody's mind seem to be absent from those consultations. So I think one of the things that consultations, particularly of the kind that you mentioned, Maheshwari, I mean, I think we need to really have a short poll before, putting out these consultation papers. Am I asking the right questions? And I think in this closed door meeting, I can say that at least I've been extremely disappointed by a whole lot of consultations that have been held, which seem to at least contain a whole lot of questions which clearly were not particularly interesting, but more importantly, conspicuously lacked questions that were actually on people's mind. So I think that needs to be, we are being overly simplistic when we say that, we have always had consultations and we have open houses and the ministers come and the TRI chairman comes, and so all that is absolutely true and worthy of some credit. But I think a vetting of the questions is a very important part of the consultation exercise, which I believe we are not doing as well on. Thank you.
I just kind of respond to. So in my mind, it's related, right? So one, if you haven't done enough studies on impact and problem areas, then there is that base for discussion and questions isn't there. So now you are in a regulation making process and you know that there is a requirement to do some process, so you have put out a consultation paper. So I think the starting point is that, and on that starting point itself, at least in areas where tech is involved, right, as a activity or conduct, we have another piece which we didn't discuss, and I just want to mention it, that we have these parliamentary committees which come up with reports, right, and a lot of those committee report, that entire ecosystem of the secretariat which feeds into those committee report, I think it might have worked well 20 years back. But today, when we deal with platforms, when we deal with e-commerce, when we are talking about IT Act and so on and so forth, that entire committee process is also very inadequate to deal with the issues properly. And one example to highlight is we had the e-commerce consumer protection rules. They came out in 2020. They got actually implemented from 21. And then you had a parliamentary standing committee report in 22 saying a whole lot of things are problematic without giving any, at least to my mind, any kind of evidence or data where we could understand what went behind their thinking. And the rules itself came out in 2021. So everything has happened in 1 year of the new rules. And then we are now debating a new set of rules. After that, Consumer Affairs Ministry started a consultation saying, now we are going to do consultation. And our first response to them was, where is the evidence that what have you noticed between 21 and now that has prompted you to do this? And obviously we don't get to hear what happened. So I think it is a sequence of process, and it is not the intent, but lack of capacity, lack of basis to start with leads to maybe sometimes bad questions and sometimes not, no ability to actually respond to some of the questions, right? So it does require some thinking.
Cool. I think we'll call it a day. We are already way past our scheduled time. So thank you everyone for joining in. I'm sure a lot of you are already aware with SFLC's work, but if you're here for the very first time, please check out their website. They do a lot of work. And like I said, for us, it's incumbent upon us to sort of understand these issues a lot better so that we can ask the right questions, we can ask questions to the right people, and we can hold media also to accountable, because like I said, a lot of the problem stops at media also as to how they decode these subjects and make us aware about these complicated issues. Thanks again for turning, and a big thank you for everyone on the panel.
Thank you, Chitranshu, for moderating that so well. I'll call upon our treasurer, Ms. Mamta Verma, to hand over a token of appreciation to our panelists.
I already got one in the morning. Well, thank you. Thank you.
Thanks a lot.
There's tea and snacks outside.
Yeah, we should have
We
something.
should have something after on the pits.
You're a lawyer or?
Have a cup of tea and then we
Yes.